Namaskar and a hearty warm good morning to one and all of you present over here. I feel it a proud privilege to welcome you all to this August gathering wherein we are going for a conceptualizing sessions. We will be embarking upon a topic that is relevant and indispensable. We are in the midst of a galaxy of erudite and competent individuals who have carved niches for themselves, and their presence adds luster and luminosity to this fabulous assemblage. We, the learners, are also no mere pushovers. Being a part of this capacity building training program on newly enacted criminal laws could prove highly educative and enormously beneficial for all of us who are the primary stakeholders of this justice delivery system. It is a privilege that is significantly gratifying for us to welcome Sri Anil Kishore Yadav, IPS Director, Central Academy for Police Training, Bhopal, Sri Rajsekhara N, IPS Director, Central Detective Training Institute, Hyderabad, Mr. Bhavanlal Meena, IPS Director, Central Detective Training Institute, Kolkata. The resource persons, along with esteemed dignitaries, respected judicial officers of the state, my revered colleagues, ladies and gentlemen, who have graced this event both physically and virtually, making this event a successful one. At the outset, I, Srimati Swapna Sagarika Mishra, Deputy Director of Odisha Judicial Academy, welcome you all to the Chief Justice Gati Krishna Mishra Auditorium of Odisha Judicial Academy. May I now request our resource persons, Sri Anil Kishore Yadav, IPS, Director, CAPT Bhopal, Sri Rajsekhara N, IPS, Director, CDTI Hyderabad, Mr. Bhavanlal Meena, IPS, Director, CDTI Kolkata, and our respected director, sir, to kindly embellish the dais. I request Assistant Director of Odisha Judicial Academy to kindly conduct the dignitaries to the dais. As a token of our heartfelt gratitude and reverence, may I now request Judicial Officer Ms. Sushrita Mishra to kindly present a flower bouquet to Sri Anil Kishore Yadav, IPS Director, CAPT Bhopal. May I now request Judicial Officer Ms. Rani Ranjita Patnaik to kindly present a flower bouquet to Sri Rajsekhara N, IPS Director, CDTI Hyderabad. May I now request Judicial Officer Ms. Suchintita Das to kindly present a flower bouquet to Mr. Bhavanlal Meena, IPS Director, CDTI Kolkata. As we begin, may I now request Honorable Director of Odisha Judicial Academy, Sri Vidyut Kumar Mishra, to kindly deliver the inaugural address.
Namaskar, a very good morning and a hearty welcome to one and all of you assembled here. Learning coupled with training creates the bedrock for any formidable enterprise to be undertaken. Learning, training, and ethics make a pillar stone for propelling the judicial officers to pinnacle of their profession. It gives me immense pleasure to state that we are here for an extraordinary occasion. As desired by the Honorable Chief Justice of India, we are going to conduct capacity building training program on newly enacted criminal laws 2023 for the judicial officers of the state with the active support of BPR&D, that is Bureau of Police Research and Development, and CAPT, Central Academy for Police Training, CDTI, Central Detective Training Institute, who are the pillar in the planning and execution of this training program. The three newly criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita and Bharatiya Suraksha Adhiniyam, which seek to replace the colonial era of Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act, which will come into force from July 1st of this year. Odisha Judicial Academy, under the leadership of our Honorable Patron-in-Chief cum Chief Justice, High Court of Orissa, Honorable Sri Justice Chakradhari Saran Singh, and under the guidance of Honorable Sri Justice Devabrata Das, Honorable Chairman, and Honorable members of the Odisha Judicial Academy and Training Committee, is committed to cause of justice by providing continuous training to judicial officers and other stakeholders of the justice delivery system. We have successfully completed an orientation training program on the newly enacted 3 criminal laws on 28 April 2024, involving 90 participants physically present and virtually the rest of the judicial officers of rest of Orissa. Today, we have with us Sri Anil Kishore Yadav, Director CAPD Bhopal, Sri Rajsekhar N, Director CDTI Hyderabad, and BL Meena, Director CDTI Kolkata, to deliberate and discuss various topics as provided in the program. I deem it my privilege to welcome all the esteemed guests to this 2-day capacity building training program. You are welcome, sir. I think this opportunity to welcome the judicial officers physically present and virtually connected with us for this capacity building training program. I welcome the 3 newly appointed district judges appointed from the bar and the 54 civil judges junior division on probation of OJS 2022 batch to this training program. I hope this training program would be very helpful not only in acquiring knowledge but refresh their mind. Once again, I welcome all of you to this program. Thank you.
Thank you so much, sir, for your kind words. With this, we have come to the end of our inaugural session. May I now request all the respected resource persons, esteemed invitees, to join our participants for a group photo session at the portico of Odisha Judicial Academy. All are hereby requested to reassemble at this auditorium at 10:30 a.m. after the said photo session for the scheduled training program. Thank you one and all. Have a great day ahead. Namaskar.
ଯୋଉଟା କହିଥିଲେ BNSS ଟା ନା ଏଇଟା ସ୍ଲାଇଡ୍ ଏଇଟା ସ୍ଲାଇଡ୍ ନାହିଁ
अच्छा अच्छा
ଏଇଟା କହିଥିଲେ BNSS ସ୍ଲାଇଡ୍ ଚେଞ୍ଜ ଯୋଉଟା এটা ফোন করে রখি স্যার সাতটা BNSS কি BNSS and BSS স্যার কইଥିଲେ এটা ମୁଁ ଓପନ୍ କରି ରଖିଦେଇଛି ଏଇଟାକୁ ଅକ୍ସିଜେନ୍ ବଡ଼ କରି
is overview of major reforms in all criminal laws, philosophy behind introducing reforms in criminal law. For this session, I request the respected resource person, Sri Anil Kishore Yadav, IPS, Director CAPT Bhopal, to take the sessions and begin with the topic. Sir, please welcome and take forward this session. Thank you.
Thank you. Learned Director, respected Sri Vidyut Kumar Misra Sahab, Assistant Directors of this prestigious State Judicial Academy, Odisha Judicial Academy, Cuttack, my dear colleagues Rajsekhar and Bhamarlal Meena, respective directors of CDTI Hyderabad and Kolkata, learned participants physically present here in this beautiful auditorium and virtually connected of whole of the state Odisha. I myself and my team from BPRND are grateful to learned director Sri Misra Sahab and Honorable Patron in Chief of Odisha Judicial Academy to invite us here to contribute to this great challenge of capacity building. For every major stakeholders in criminal justice delivery system, BPRND, Bureau of Police Research and Development, Delhi, New Delhi, under the aegis of Ministry of Home Affairs, Government of India, has been conducting various capacity building programs. So some for judiciary, police, prosecution officers, forensic scientists, and prison and correctional services also. So 5 major pillars of our criminal justice delivery system, we have been conducting such programs right from very beginning. As we are aware that on 20th of December 2023, these new laws, those bills were passed by Lok Sabha, and the very next day on 21st December year 2023, these were passed by Raj Sabha also, and 4 days later on the 25th, Honorable President of India kindly granted assent, and that very evening these were duly notified through Gazette of India Extraordinary. And within 48 hours of that notification, to be precise, 36 or 38 hours within, we started on 27th of December morning, we started such programs. First program was conducted in the Central Academy for Police Training, Bhopal. And in that same week, other CDTIs stands for Central Detective Training Institutes under BPRND. So 2 of these young directors are here. Director CDTI Hyderabad, Sri Rajsekhar N, and Director CDTI Kolkata, Sri Bhamarlal Meena. So all of us, our team in BPR&D, have been conducting such capacity building programs for various stakeholders from 27th of December 2023. So I once again I would like to express our gratitude to Sri Misra Sahab and Honorable High Court Odisha judges who have allowed us to come here and to contribute in this great challenge. As we are aware that for greater part of our careers, most of us present in this hall, beautiful hall of this auditorium, will have to work with both sets of criminal laws. Because due to that effect of repeal and saving part, repeal, of course, these old set of criminal laws will get repealed from 1st July 2024. But saving clauses will save those proceedings which are already there pending or being conducted. They will be governed by old sets of criminal laws. So we will need to work with both sets simultaneously. New cases, new proceedings with these new sets of criminal laws and already pending immediately before 1st July, those by this existing sets of criminal laws, which will be old till then from 1st July. And we may not be aware otherwise because we are busy with our day-to-day works. But this is the fact that sisters and brothers in Jammu and Kashmir have already been working with two sets of such laws. After abolition of Article 370 of Constitution in the year 2019, since 31st October 2019, they have been working with two sets of criminal laws, and now they will need to work with three sets of criminal laws from 1st July onwards. So I welcome you all participants, learned participants, and I'm sure that with this program, this 2 days capacity building program, though initially under the direction of Ministry of Home Affairs, we prepared 3 days module, and that was Honorable Chief Justice of India was kind enough, very kind of him, that he took the initiative to inform all of the high courts of judicature to regarding this capacity building effort and BPR&D role and all. So due to that, but due to constraint of time, learned judicial officers, this was not possible to for that 3 days module here. So this is being compacted and consolidated to within 2 days of this program. So as we are aware, these out of these three newly enacted laws, first one is Bharatiya Nyaya Sanhita, that is Act 45 of year 2023. And second one is Bharatiya Nagarik Suraksha Sanhita, that is Act 46 of 2023. And the third one is Bharatiya Sakshya Adhiniyam, Act 47 of 2023. And these new enactments are going to replace respectively Indian Penal Code 1860, Criminal Procedure Code 1973, and Indian Evidence Act 1872. So one of these three, that is Criminal Procedure Code, was freshly enacted by our independent parliament in the year 1973-1974. That is called Criminal Procedure Code 1973. But in fact, that was finally enacted in the year 1974. So that is Act 2 of 1974, and which was which came into force from 1st of April 1974. So CRPC was enacted freshly, newly by our independent parliament, but during these 50 years, exactly 50 years, because that was enacted in the 24th year of our Republic of India, CRPC 1973. And these three new enactments have been enacted in the 74th year of Republic of India. So between those 50 years, technological revolution and other expediency made it expedient to reenact that also. So with other two purely colonial enactments, because they were not freshly enacted so far, along with those two, that is IPC and Indian Evidence Act, this CRPC was also newly enacted again. So thus these three new laws have been enacted, and philosophy behind these is number one, to remove any whatsoever vestige of colonial rule, number one. Number two, to upgrade ourselves with these contemporary requirements of and challenges of criminal justice delivery system, to make our criminal justice delivery system efficient, more efficient, speedy delivery, and accessible to every party. That is not only victim, but this should be equally disposed to every party, including accused. That's why our law framers have added these terms in the titles of these laws themselves. Like, we are not going to have any Bharatiya Dand Sanhita. Rather, the name title of this act, this is given as Bharatiya Nyaya Sanhita. From Dand to Nyaya, from punishment to justice. Similarly, our procedure code is named as Nagarik Suraksha Sanhita. As we are aware, Nagarik Suraksha Sanhita, this state of Odisha and language of Odisha, that is Odia, is also a language belonging to same linguistic family that Sanskrit and Hindi are. That is Indo-European language family. So this is this is not difficult for anybody in even in this state of Odisha to completely grasp the meaning of Nagarik Suraksha. So Nagarik Suraksha, from procedure to Nagarik Suraksha, and from Dand to Nyaya. And Indian Evidence Act 1872 was in Hindi and maybe some other languages of Indo-European language family. must were called by this name only, Bharatiya Sakshya Adhiniyam. But now this, whether written in Roman, English, Roman alphabet, or these languages, this will be called Bharatiya Sakshya Adhiniyam only. This is not going to be called in any manner in not even English as Indian Evidence Act anymore, because the title of this act is like this only. Here this is written in the Hindi Anubad, Hindi translation, that is also being notified. That is written in the Devanagari script, as that is the script in vogue for Sanskrit and Hindi, and also Marathi language is also written in that script, Devanagari. So in the Devanagari script, that is written Bharatiya Sakshya Adhiniyam. Similarly, in the Roman script also, English translation, that is written Bharatiya Sakshya Adhiniyam, BHARATYIYA, etc. Our need of these enactments is stated under those respective statements of objects and regions of these three enactments, draft bills, that is there, and Honorable Union Home Minister in his parliamentary debate speeches, he also reiterated those points, those objects and reasons behind these enactments. So that was the part of debate, and they are part of this history of our this legal evolution. Basically, those in nutshell, 2-3 points are important all through regarding all three enactments, those statement of objects and reasons. That is to come out from that shadow of colonial era and to update and upgrade our laws according to our requirements, social, economic, and justice delivery system requirement, and to upgrade ourselves with modern technological advancement, developments in the interest of faster and speedy justice delivery. My other colleagues in their respective sessions, other subject matter experts, SMEs, in their respective sessions covering those acts, Nagarik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam, they will in detail tell about those provisions, discuss among all learned participants. And here in this particular session, I will just very briefly go through them, and thereafter my session regarding Bharatiya Nyaya Sanhita, I will cover them in some more detail as far as this time allows. So major changes are, we can roughly we can discuss them regarding three new acts only in that sequence. Bharatiya Nyaya Sanhita, major changes are, that is, number one, this is the Sanhita which is most radically reorganized in the terms of chapters and sections. Bharatiya Nyaya Sanhita is most radically reorganized. Other two acts are not that radically reorganized. There we will find that sequence of those topics, chapter scheme, and that other related things are in that order as it is in the existing laws. There is no radical changes there in the Nagarik Suraksha Sanhita or Sakshya Adhiniyam. But in Nyaya Sanhita, this organization scheme is very taken on a very revolutionary ground. So whole system, where will you find those sections in the IPC later part or middle part or earlier part? That will not be necessarily we will find in the Bharatiya Nyaya Sanhita. Like the most important, most serious offense, murder, there in Bharatiya Indian Penal Code, that is section 302, but here that is section 103 here in BNS. Similarly, second most heinous crime or equally heinous crime, rape, in Indian Penal Code, that is 376. Here, that is defined 375 IPC and 376 penalized here. That is 63 and 64 in the BNS. So, scheme has been that they have carved out a new chapter in the BNS, that is offenses against woman and child. And that this chapter has been given the topmost priority. So this is the first substantive penal provision chapter. Overall chapter 5th. Initial chapter 4s are preliminary and general explanations, general exceptions, etc. But after them, first chapter which defines offenses and penalize them, that is chapter 5, which deals with the offenses against woman and child. In the Indian Penal Code, this is scattered all over the code. But here, this has been consolidated in a single chapter, newly carved out. Immediately after that comes the next chapter in that order of the most importance given by the law framers of our nation. In that order, that is offenses against human body. There these offenses come. So in a huge way, this has been reorganized. And regarding sections, as in the IPC, sections are 511 original sections, and here these are 358. So it may seem to one that those huge number of reduction of numbers of sections, but content-wise, this is not the case. This is due to that radically reorganization scheme. Many independent individual sections of Indian Penal Code have been consolidated in lesser number of sections in form of subsections and clauses. Like definition sections from in the IPC, starting from section 6 onwards up to 52A, all of those sections have been consolidated here in the Nyaya Sanhita under section 2, definition section, enumerated in form of Arabic numeral subsection named 1 to 39. Similarly, many related offenses have been put here in the Nyaya Sanhita under a single section, and different offenses are defined in form of separate subsections of that section. So this scheme has been most radical in the Bharatiya Nyaya Sanhita, and this is not the case with other two acts. So practical impact of this is that this is going to be more challenging to work with both new and old set of criminal laws regarding this Sanhita, Bharatiya Nyaya Sanhita, because there the gap will be huge, and there cannot be found any regular sum formula. But regarding other two acts, this reorganization scheme is not that drastic. So we may find it a bit easier to grasp, like those proclamation provisions in the Bharatiya Nagarik Suraksha Sanhita are given under section 84, whereas in the CRPC that is 82. Not much difference. This difference gradually increases. When we come to FIR provisions in the CRPC, that is dealt with under section 154. But here, this gap increases here, so difference here is 173, 19 sections difference is here. This is 173 here. But once you are sure that 154 is 173 in the Nagarik Suraksha Sanhita, then this is not difficult to get that, okay, 155 of CRPC must be here 174. Like 156 CRPC is 175 BNSS, like this. So this may be a bit easier in comparison to BNS. So major changes in the BNS, as I have already mentioned, that this radical reorganization, that too regarding offenses against women and child, that chapter 5, there also under this chapter regarding provisions, there are some important, very important new additions, like section 69, which deals with newly added section, which deals with exploitation of women by deceitful means, including false pretense of marriage or by promise of giving employment or promotion, etc., or by concealing one's identity. So similarly, section 95 is also new, absolutely new, which deals with the offense of hiring children to commit a crime, hiring, employing children. Till now, we can fix such criminals behind those children. We can fix only under provisions of conspiracy, 120B, etc., and abatement, etc. But here, under section 95, we'll find a completely new provision to fix those criminals. Similarly, a very far-reaching impact section is there, section 70, subsection 2, which corresponds to section 376 DA and DB, gang rape provision. So in the IPC, there are two age categories under this particular gang rape offense. That is 376 DA deals with if gang rape is being committed upon a victim of less than 16 years of age. And section 376 DB deals with a victim of less than 12 years of age. But here, under section 70, subsection 2, this scope is immensely expanded by providing this threshold of minimum age under this particular penal provision as not 12 or 16. The punishment, ultimate punishment, which is given there for less than 12 years of age, 376 DB, that is now being provided for every woman who is minor, a child under 18 years of age. So under 12 years of age, punishment, which is ultimate punishment possible in any justice delivery system, that is capital punishment, that is now available for any child gang raped, woman child gang raped. Any girl under the age of 18 years gang raped, our learned courts will be able to award sentence of capital punishment. So this is a huge change there. And some offenses, some sections have been made gender neutral, like voyeurism etc. So gender neutral from the perspective of offender also. Of course, this has not been case in the definition of rape, though certain people argue in the favor of such systems, but this is not still there. On that account, that definition of rape is same as given under the IPC. So there is no change in the definition of rape given under this section 375 of Indian Penal Code, and here corresponding 63 BNS. So chapter 5, crime against woman and child, has got these some of briefly I have mentioned these changes. Under the chapter of offenses against human body, there are some very important and far-reaching changes there also. Like under the category of murder, there is a new offense added, which is in common parlance known as mob lynching. This is being added in form of section 103 subsection 2, where 5 or more persons commit murder on ground like race, caste or community, religion, place of birth, region, etc. For them, this provision is has been added. Similarly, some other new provisions like new whole sections like organized crime, petty organized crime, and terrorist act have been added under that chapter, crime against human body. One chapter is completely, one chapter of Indian Penal Code has been excluded. I mean that is not there in the Nyaya Sanhita. That is chapter 13 of Indian Penal Code, which deals with offenses related to weights and measures. Section 264 to section 267. 4 sections are there under that chapter 13 of IPC. Those have been excluded. Reason being, a separate act was already enacted in the year 2009, but simultaneously we could not repeal these provisions. Unlike the case of Prevention of Corruption Act, which was enacted in the year 1988, simultaneously we repealed corruption-related provisions under the IPC. That could not be done in the case of Legal Metrology Act 2009. That deals with weights and measures. Now lawmakers rectified that oversight earlier by not including those provisions in the main Sanhita. And other chapters have been accommodated here in the IPC with some new additions, which we'll discuss when we come to overview of BNS proper. So BNS is basically radically reorganized Sanhita with some very important additions, and those additions, of course, organized crime, petty organized crime, terrorist act, and section 69, section 95, etc. But this is substantive law, as we are aware that these 3 acts represent first substantive law, next procedural law, and third one adjective law. So substantive law attracts the most of the headlines, of course, due to obvious reasons that offenses are defined there and penalized, criminalized there. But if we think in a deeper terms, one justice delivery system's efficiency or delivery depends more upon the procedures. So procedure code here is Nagarik Suraksha Sanhita that has got, up to me, more radical changes. Here in substantive law, we provide some offenses, increase, enhanced, etc. As a BNS, there have been many offenses, 36 offenses where penal punishment has been enhanced. Kinika, someone virtually connected has got mic unmuted. So may kindly mute that mic. Someone there. This is a cause of distraction. Kindly mute your mic. Whoever has left that unmuted. Sorry, in this presentation, due to paucity of time, I could not prepare that presentation, complete overview. That's why I am talking orally only. I have this presentation for BNS. Further that we'll use PPT. But general overview of these criminal laws, I forgot to get into this. Sorry for that. That's why I'm not able to add this on PPT. So I was talking about that procedure code. So that is Nagarik Suraksha Sanhita. That has got far more radical provision if we measure on account of far-reaching impact. Procedure impacts us in a huge manner. Though for a layman, it may seem that some offense, if punishment has been increased, that make a huge headline, or some offense up to particular appreciation of particular individual has not got that severe punishment, that may be eye catching and headline making thing. But up to me, procedure codes are even more important. If not more important, they are not any less important than substantive provisions. If we analyze these changes, on this perspective, then we may find that Nagarik Suraksha Sanhita is going to be a far more radical, revolutionary enactment in comparison to other two laws changes. Though this is being enacted by the same independent parliament of our great nation, and not after 163 years or so, that huge gap of time, rather only within 50 years of those two acts, CRPC and BNSS. But this is going to have far more greater, far more revolutionary impact on our criminal justice delivery system. So this BNSS, their number one thing is, we are going to use these technological developments achieved by whole civilization, human civilization, between those 5 decades. By at every stage, these audio, video, electronic means, etc., have been utilized. कोई इसमें कोई ऐसा सिस्टम नहीं जो लॉक हो जाए, जो जुड़े हुए हैं उनका ऑटोमेटिकली सभी लोग म्यूट हो जाएं, कुछ इस तरह का, बिकॉज दिस इज डिस्ट्रैक्शन हो जाता है. थैंक यू. So audio, video, electronic means are going to be used in each and every possible stage. of our criminal proceedings, right from EFIR to trial. Section 530 completely that there is no bar, that is on the discretion of learned court, that each and every possible proceeding under the Sanhita can be conducted through audio, video, electronic means. That is the second last section of the Nagarik Suraksha Sanhita. And during those other sections, in under each respective sections dealing with particular subject, there is a specific provision to enable concerned stakeholders to use those audio, video, electronic means. And there is section 105 BNSS newly added, which makes every proceeding of every operation of search and seizure, conduction of search and seizure by investigating agency, to be mandatorily recorded audio visually. Uski, that is necessarily, mandatorily shall be recorded. Section 105 newly added, and corresponding section 185 BNSS, which deals with search without warrant. There also this is reiterated. So such provisions are very important, which at the one hand enable us to utilize this technology to utmost possible manner in the in our justice delivery system, and on the other hand, this is expected to enhance transparency and accountability in the system. Like some certain procedure is mandatorily being video recorded, then their chances of abusing, misusing by investigating agency gets minimized. As we are aware, in the case Safi Muhammad versus State of Himachal Pradesh, there were these issues raised, and Honorable Apex Court directed us on certain accounts. Now, this will be there completely there implemented by such provisions like Section 105 BNSS. Second very important aspect of Nagarik Suraksha Sanhita in the direction of transparency and efficiency and speedy delivery of justice is specific timelines. Specific timelines, certain timelines are already there under CRPC, but there are certain timelines which are further defined, more categorically defined to leave least scope of ambiguity or confusion, and some are newly added. These timelines are even related to trial, adjournments, etc. So these specific timelines are expected to speed up our justice delivery system, which in turn will certainly help enhancing our quality of our justice delivery system. As there is a very famous this that justice delayed is justice denied. So to tackle this issue, they have provided specific timelines in our Nagarik Suraksha Sanhita. Another very far-reaching impact carrying provision is proclaimed offender-related provision. Proclaimed offender is dealt with under Nagarik Suraksha Sanhita by under section 84. CRPC, this is section 82. So there is no difference, that is exact reproduction of subsection 1 to subsection 3. 82.1 to 82.3, they, and that corresponding 84 subsection 1, 84 subsection 3, there is no change. But there is a huge change, radical change in regard to proclaimed offenders that is dealt by subsection 4 of these respective provisions. So under CRPC, there are certain 11 or 12 sections of Indian Penal Code being mentioned regarding offenders related to those sections. We are able to declare proclaimed offenders. But now, this scope of this subsection has been expanded limitlessly by providing that for offenses punishable with 10 years imprisonment or more, or life imprisonment or death penalty. So here it is written offenses punishable for imprisonment for 10 years or more. There in the CRPC 82 subsection 4, there are certain IPC sections mentioned, while here under subsection 4 of section 84 Bharatiya Nagarik Suraksha Sanhita, this is mentioned that offenses punishable for 10 years or more. So this expands this proclaimed offenders scope hugely, limitlessly, because now not only IPC offenses which are punishable with 10 years or more, but also it is not written that this is for IPC only. So this will cover now other special penal provisions, special acts also. And proclaimed offenders related this scope is not only up to this significance that this is they will be called proclaimed offender. This has going to have bearing upon that radical provision which is completely new to our jurisprudence, trial in absentia. Trial in absentia, section 356 Bharatiya Nagarik Suraksha Sanhita. So in case of proclaimed offenders, we will be able to try those proclaimed offenders in absentia. That is a huge provision, huge section in detail, and that starts with that non-obstantive clause, notwithstanding anything else given in this Sanhita, this. So there are, and that is debatable, of course. But as someone during those participations, learned participant, answering to another participant's queries, that participant rightly said, learned judge, that right to be heard personally is different from right to evade trial. That gentleman who has been duly declared a proclaimed offender, and after that also before commencing this trial in absentia, there are some other opportunities are also being given, then one cannot claim endlessly that I have got this right under natural justice, ode alteram partem. So, okay, you have got that right, but you are now willingly, voluntarily evading trial. That's why after being given so many opportunities to present yourself, to appear yourself before the court, you are evading that. So sovereign state is going to use that right on its part. So this proclaimed offender provision is going to be utilized in the form of trial in absentia. That is there. So like these certain provisions are in the Nagarik Suraksha Sanhita, which has got a very huge impact on our criminal justice delivery system. There are certain other provisions which they are debatable also by what perspective we see them. Like for a person like me, though I am a police officer, but I may not like certain provisions which unnecessarily enhance powers of police. I am not of that opinion. So I am not personally, of course, we are public servants and we are going to uh, going to uh, going to deliver on our part the best possible manner which is being mandated. But personally speaking, that preliminary inquiry, I think that that is better. We were close to those guidelines issued by the Honorable Constitution Bench of Honorable Apex Court in the case of Lalita Kumari versus State of UP. So under section 173 subsection 3 in the BNSS, we have provided that regarding offenses punishable for imprisonment for less than 7 years, but not less than 3 years, 3 years or more, but less than 7 years. Their police officer, with the prior permission of an officer not below the rank of Deputy Superintendent of Police, that officer in charge in the police station, they will be able to conduct preliminary inquiry. And there this term, what? Preliminary inquiry, what for? What is to be ascertained through preliminary inquiry? So where Lalita Kumari case talks about to ascertain whether cognizable offense exists or not. But here we have provided in the Sanhita that to ascertain prima facie case exists. So this has got a huge difference again. So I am apprehensive that some unscrupulous elements in the police may abuse and misuse these provisions, because this is already not very easy for a genuine bona fide complainant to get an FIR lodged. Some officer in charge somewhere, they are more sensitive, they will do it promptly, but many of us are not that sensitive to the justice, and they try to uh, they don't straight away lodge an FIR. More so even after this Nirbhaya gang rape case, this very horrendous incident which took place in the year 2012 in the national capital. After that, Honorable Justice J.S. Verma Committee and that ordinance, and then Criminal Law Amendment Act 2013. That act has got a that is a landmark act in the in our criminal justice delivery system regarding crime against women, that 2013 act. Through that act, many insertions were made in all three criminal major acts, and one of them is very important. That is 166A Indian Penal Code. Here in the Bharatiya Nyaya Sanhita, we'll find that in form of section 199 PNS, exactly reproduced. Section 166A is completely word to word by word, comma, everything. 100% reproduction of section 166A IPC is section 199 BNS, Bharatiya Nyaya Sanhita. What is there? This section deals with, earlier that was a non-cognizable offense, public servant related provision, that is section 166 IPC. This 166A was added, public servant disobeying direction under law. And subsection C of this provision, 166A or 199 BNS, says that certain offenses are enumerated there and listed there. Those are sexual assault on women and acid attack cases and human trafficking cases. So these provisions are there that if someone fails to lodge a report under section 154 CRPC, then that public servant is liable under these provisions. So this is written public servant, like mostly these reports are only police officers are. If you fail to register an FIR where you have been informed that sexual assault has taken place on woman or acid attack or human trafficking, then you don't even have any margin for preliminary inquiry even by given by Lalita Kumari case. No. By law itself, this has been made mandatory that you have to straight away lodge an FIR. Of course, no law has directed in any manner, indirectly or implied otherwise, that police officer should charge sheet someone who is innocent. No, false case, declare false. There are other provisions. If someone is trying to fabricate someone falsely, then there are provisions, section 182, 211, IPC, etc. You fix them therein. But you don't possess any right to delay or deny that registration of FIR. This has been made complete obligation on your part, police officer. But still we could see not only some cases here and there, remote cases, the national capital of our nation, where many very influential celebrity girls, which have not only made names for themselves, but our country also. They were struggling to get an FIR lodged against a very influential person. And that FIR got lodged only after Honorable Apex Court's intervention. When that notice was served, then only police registered that FIR. But of course, system is like that, that one like me may not be very, very happy or rather disappointed even after that petition was disposed by Honorable Apex Court, where Honorable Bench failed to order to get an FIR registered against that police officer who failed to lodge an FIR on information given by those girls prior to intervention of the Honorable Apex Court. So 166AC, they are all already liable, but still we have been playing with that. So I'm apprehensive that once this statutory provision of preliminary inquiry, holding preliminary inquiry is given, those unscrupulous and unfair elements in the police may abuse it, these provisions, misuse them. But there are many very progressive provisions under section, that same section, that is 173, dealing with FIR. That is zero FIR. Zero FIR has been statutorily made feasible, viable, and obligatory. Now, they cannot, of course, this zero FIR concept was there, but now this statutory provision has been made here. So this is going to make a very progressive impact on in favor of victim, informant, and EFIR. Though these we will need further some rules and standard operating procedures to be issued by concerned authorities, so that these provisions can be implemented in a more objective manner, in a proper manner. So EFIR and zero FIR, those are very enabling provisions under the same section. Then there is that, as I said, that best technological utilization in the criminal justice delivery system is one of the most important motto and object of our law framers uh, to enact these laws. So there is section 176 subsection 3, which makes it mandatory where offenses are punishable with imprisonment for 7 years or more than 7 years. The visit of forensic science expert to the scene of crime. Though due to this fact, which is realized by our law framers, that forensic science and related infrastructure is not everywhere that good in every state. So they have provided that respective state governments within next 5 years will notify that date from this provision will mandatorily come into force. So this will definitely enhance this use of forensic science and scientific investigation by our investigating agencies where offenses are more serious, that is 7 years or more punishable with. So these are some of those very important provisions which are there in the procedural law. There are some concerns shown by that judgment Priyanka Srivastava versus State of Uttar Pradesh. So they have tried to save public servants from undue harassment by some litigants. That's why in the case of those complaint cases, they have provided that the learned court won't take cognizance before this report certain where these allegations are under discharge of one's duty, public servants. So that department, some superior, that report will be sought, and after getting that report only, learned magistrate will be able to take cognizance of that matter. So on 20th of April this year, there was a national conference organized by the Ministry of Law and Justice in New Delhi. And Honorable Chief Justice of India was chief guest in that national conference. So there, one of panelists, Honorable retired Justice, and he's a member of Law Commission also. He expressed his disappointment over this provision. He said that already we have got very few options, those victim informants who is harassed by unfair and unjust acts of some public servant, though under color of that his public duty. But where will they go? Police want registered, obviously, due to their influence, that department or that person's public servant's influence. So they come to victim informant may come to Honorable Learned Court under that provision of CRPC. But where will that person go? Now, they are not supposed to submit that report fairly. So he has got his concerns, Honorable Retired Justice, and I tend to agree with him more than with this provision. Okay, but that is, those are individual opinions, and Honorable Retired Justice is the member of Honorable Law Commission, so he will be in a better position to further evolve this debate or further contribute to this debate. So there are these few provisions which has been discussed regarding Nagarik Suraksha Sanhita on point of overview. Those other provisions are mostly, as I have discussed, that Nagarik Suraksha Sanhita technology use the best possible manner and specific timelines to ensure speedy delivery, and these proclaimed offender and trial in absentia, these provisions. So these cumulatively, this collective impact of all those provisions has to be expected to be very good on our justice delivery system and enhance our quality of justice delivery. Regarding that third act, Bharatiya Sakshya Adhiniyam, this is the act Bharatiya Sakshya Adhiniyam. There, of course, this use of technology has been ensured there also. But after this enactment of Information Technology Act 2000, their corresponding provisions were already there in the Indian Evidence Act. So these new additions in the Indian Evidence Act in form of Bharatiya Sakshya Adhiniyam are comparatively not that radically new or absolutely novel, but they have facilitated further this use of technology, which was not available with those IT Act insertions, because this issue of technical issue, primary evidence and secondary evidence issues, they have widened this utilization, widened this scope to utilize in a greater manner this electronic evidence. So this primary evidence and secondary evidence issue they have discussed very sensitively in the Bharatiya Sakshya Adhiniyam to enhance this better utilization of information technology in the evidence system. And that is basically a main thing. Though one of very learned retired honorable judge, Justice Ved Prakash Sharma, he's an authority over this evidence law. So he was discussing, we were discussing there in the academy CAPT Bhopal, that this new edition, complete new edition section 61, so how it is basically different from already inserted sections in the year 2000. So certain these things are there. Certain at some places we find that maybe due to some hurry or what, some drafting could have been better of this. That legal drafting is such a very sensitive issue that certain authorities on this account, they have shared these views that okay, this drafting could have been far more nuanced, and some of our learned resource person were sharing the experience that someone who was in that drafting committee which has drafted these laws, they asked them also that see here certain issues there. So they told, okay, these things can be taken care of in subsequent amendments, etc. So these are there, like certain oversights are very conspicuous, like abolition of section 377 Indian Penal Code, complete exclusion. So this is going beyond, far beyond than Honorable Apex Court judgment in Navtej Singh Johar versus Union of India, 2018. So that judgment has decriminalized the consensual part between adults, nothing less, nothing more. That Honorable Apex Court judgment did this consensual part, decriminalized between adults. But now, from 1st July onwards, we will be in a strange position where if someone against his will is victimized by committing that act upon oneself, one adult who does not enjoy this identity of being a woman, that is not protected. Women, of course, that particular act is act is there defined under the definition of rape itself. Section 63 definition, section 64 punishment, that will be covered there. Boy, child, under 18 years of age will be definitely covered under the POCSO. But adult men or adult transgender or those innocent animals which were covered under that provision 377, which are being covered, so they are unprotected. So maybe sooner than later, we will see some further amendments later by our honorable parliament to tackle these issues. So I guess I have already taken much more time what was allotted to this first session. So sorry for this excessive time taken. So this this much for this first session. General overview of all of these new criminal laws. Any queries? Yeah, or subsequent sessions. If yeah, अभी कुछ पूछें? Queries? Oh, with kind permission of learned director Misra sir, if any queries are there, and other queries can be even if you are not we are not able to tackle in this particular session, we can take them in the respective sessions also. So as you like. Any queries, please? Thank you.
Thank you, sir, for your deliberation. With this, we come to the end of this first session. And again, we will reassemble here at 12 noon after the tea break. Thank you. Session is on Bharatiya Nyaya Sanhita 2023 overview and comparison. Now, I request Sri Anil Kishore Yadav, Director CAPD Bhopal, to continue with this session. Thank you.
Thank you, respected Director Sri Misra Sahab. So, Act 45 of year 2023 is going to replace the Act 45 of 1860. So this is a mere coincidence that both of these acts are 45th acts of their respective years of enactment. 163 years gap, 1860 Britishers enacted Indian Penal Code de novo afresh. Till then, here in our great nation, there were different various kinds of criminal justice delivery systems were existed. Though for many centuries, there was a centralized imperial government in Delhi, Mughal Empire. So criminal justice delivery system was more or less streamlined in favor of Mughal system, most of the parts of India. And they were mostly dependent upon their religious law, Sharia law. Criminal justice delivery system was run by that, Qazis. And civil law, of course, was more decentralized, more customary, those in the various regions. So Britishers inherited Mughal imperial justice delivery system, and they themselves equipped with European Renaissance thoughts, legacy of Roman law, civil law, European nations, deliberations. So they did a great job by trying to codify justice delivery system and streamline. And we are more or less, we have inherited that system only. So even on today, as we have enacted these new criminal laws, civil part is still, civil procedure code will still continue till our parliament take up that task to reenact that maybe in a near future. We don't know. But criminal justice delivery system is still a great legacy from that colonial era. And as we have discussed, we have tried our parliament to remove those vestiges of colonial this thing. So there is a maxim in Hindi, not maxim. This is a part of a couplet by a later medieval poet. So that is सार सार को गहे रहे थोता दे उड़ाए. So they are going to take this most important and valuable substance of that system and removing that which is not needed and customizing as per our needs of an independent, free democratic republic comprising a very complex society, very diversified, great, a world in a nation itself. So Act 45 of 2023, 163 years later, 163 years later, after this enactment of Indian Penal Code in the year 1860, we are going to have from 1st July this year, only 1 month has left to get our new Sanhita, Nyaya Sanhita. So as I mentioned, this was notified on 25th of December 2023, and 2 months later, on 24th of February, the government, central government, which is empowered through that subsection 2 of section 1 of Bharatiya Nyaya Sanhita itself, delegated power. Power has been delegated by the legislature to the executive, that is central government of India, to appoint a date of commencement of these new laws. So subsection 2 of Bharatiya Nyaya Sanhita empowers central government to appoint a date of commencement, and there is a provision that government can appoint separate dates for separate various provisions. So by exercising that power, Government of India, through the Gazette notification extraordinary, notified whole nation that these acts will commence from 1st July 2024, except this section 106 subsection 2 of Bharatiya Nyaya Sanhita, and of course corresponding entry in the first schedule of Bharatiya Nagarik Suraksha Sanhita. So we may like to compare these two laws. We can say one code and another Sanhita. And of course, here in new enactments, in place of code, whether it is used in context of referring that same code like Bharatiya Nyaya Sanhita and Bharatiya Nyaya Sanhita, or cross references like Bharatiya Nyaya Sanhita talking about context, cross-reference of Bharatiya Nagarik Suraksha Sanhita or vice versa. So code is replaced everywhere with the term Sanhita, because in these two complementary Sanhitas, there is nowhere this term code is used. That is Bharatiya Nagarik Suraksha Sanhita 46 Act, and this is Bharatiya Nyaya Sanhita. And similarly, where is any reference regarding Indian Evidence Act in the IPC? Similarly, there this will be written only Adhiniyam. This is replaced Act, replaced by Adhiniyam, as that name of adjective law is now going to be Bharatiya Sakshya Adhiniyam. So let us compare this content of these two acts, that is Code and Sanhita, IPC and BNS. So original number of sections in IPC is 511. And here in BNS, this is 358. But if one thinks that this is the actual ratio proportion of content, then that will be a wrong impression. That will be a misconception. Now let us discuss it thoroughly. So inserted sections. Within this whole huge period of 163 years, we have got 64 insertions. And as we are aware, this scheme of numbering of those sections of laws, acts, insertions, though they may be separate, independent provisions in themselves, but they are not assigned to a different whole number because of the regions of convenience. Otherwise, these numbers coming afterward, those get disturbed, etc. So when lawmakers found this expedient to add something like death caused by death caused due to rash and negligent act, and that is close to related to culpable homicide not amounting to murder, then they inserted new section, but that section was named as, designated as section 304A, capital A, Roman alphabet capital A. And further in the year 1986, when we needed that this menace of bride burning and this death caused by matrimonial, so dowry death, when we needed that, we inserted that, and that was assigned number as 304B. Like cruelty in the matrimonial house, cruelty on woman, that was added in 1983. So that was inserted as 498A. Likewise, those Criminal Law Amendment Act 2013, sexual assault on women, those many new sections were inserted: 376A, 376B, 376C, 376D, 376DA, DB, etc. So this is the way how our acts, legislations progress. Further amendments, respective amendments insert different sections, but they are designated not a separate number, but those A, B, etc., C, Roman capital letters assigned to them. So by this scheme, by this process, during whole this time, 64 sections being added in the IPC. So this is not total number of sections 511, but rather 64 these inserted sections, that makes 575. And if we see this serial number third, number of sections repealed through subsequent amendments, 21. So this was not a one-way process. 64 new sections were inserted at the same time. 21 sections were repealed during this period. So net number of section we are working with, existing number of sections in Indian Penal Code for all practical purposes. Though total number due to that original scheme and that will be called 511, but when we are discussing it in detail, threadware, then we can see that number of sections in the IPC we are presently working with is how many? PPTs before you, you can see this screen, serial number 3, 4, serial number 4. So this is 554. Presently, number of these provisions in terms of actual sections, individual sections, technically, practically, they are 554. So how much of 554 we are going to have in our new Sanhita, BNS? How many? So kindly have a look at this serial number 5. There is written IPC sections not included in BNS. So this number is 19. So 19 sections are not going to be included in the BNS. This has been dropped. So total IPC sections included in BNS, that total number is 535. So we come to this figure that we started from 511, 64 new inserted in the meantime, 21 repealed in the meantime, remaining 554 presently we have been working with existing IPC and 19 excluded. So 535 sections of IPC, those provisions we are going to have either in complete form of reproduction or with some rectification, modification, with some consolidation, reorganization, whatever manner. We are going to have this content of 535 perimeteria. These things we are going to have in our new Sanhita, 535. So now let us have a breakup of 535 provisions in form of sections. So 535 out of 535, 286 sections individually corresponds to same number of sections, that is 286 of Bharatiya Nyaya Sanhita. So 286 section of IPC equal to 286 sections of BNS also. Remaining 249 sections of IPC are incorporated either complete reproduction or with some changes. These have been incorporated within 62 sections of BNS. So 4:1. 4:1 ratio approximately, because if you multiply 62 by 4, it will come to 248 and this figure is 249. So 249 are being incorporated within 62 sections. And of course, new sections added in BNS, this number is 10. So 286, 1:1 correspondence, and 62, 4:1 correspondence, and 10 newly added. This makes total number of sections in BNS as it is 300. How many? 358. So this is the breakup of content comparison in this particular manner. You may not find it any publishers of whatever stature they may be in the market on new criminal laws. We have tried to prepare this detail to for. So in form of graphic, this difference comes to finally, because 535 corresponds similarly in this BNS. So actual difference of content here is the difference between 19 and 10, 19 excluded and 10 newly added. So this is the actual difference in volume. Sorry. Comparative statistics. So again, we have already discussed this number of sections 511 and 358. We have already, in details, we have got that idea what is going to happen with these existing provisions of IPC. Now, we may like to talk about number of chapters. So in the IPC, there are 23 chapters. And I must qualify that sentence by saying that this number is original number. But subsequently, 3 chapters were added, inserted in the IPC during those historical 163 years. So, chapter 5A, chapter 9A, chapter 20A, these 3 chapters were inserted later, at later stage in the IPC. So, presently, total number of chapters in the IPC is 26, not 23. And out of these 26, except one section, as I have already mentioned, that is except one chapter, as I have mentioned, that is chapter number 13. Except that chapter number 13, other 26, other 20 remaining 25 chapters have been incorporated in BNS. And BNS, 20 chapters, the last chapter is repeal and saving, consisting of only one section, that is the last section of the Sanhita, that is section 358, repeal and saving. That was not required in the IPC. As I have said, historically, IPC was enacted afresh, de novo. So, they didn't have anything to repeal per se or to save anything. So there is no such section in the IPC, repeal and saving. Of course, such section is there in the CRPC, because CRPC we freshly enacted in the year 1973-1974. So there is, of course, that section there. But in IPC, there is no such section. And this chapter 20th, if we take into this fact into consideration, then remaining 19 chapters of BNS consist of whole the content of remaining 25 chapters of IPC, except chapter 13. As I have mentioned, that is excluded, that relates to weights and measures offenses, which have been covered already by Legal Metrology Act 2009. So 19 chapter, 25 chapter of IPC are incorporated in, and in these 19 sections, this offenses against woman and child, this is newly carved out. So there can be another set of data to compare these two acts. That is what, as this is a substantive law, this is substantive law, these 2 acts are dealing with, the code and the Sanhita. So substantive law, we are mostly bothered about offenses, how they are defined and how they are penalized. So number of offenses, if we consider between these 2 acts, we find that in the IPC, total number of offenses is 483. Of course, number of offenses and number of sections are different concepts. Many sections do not contain any offense at all. They are definition sections or explanatory, like that, or principles, doctrines, they are defined, those things. And many sections may have many offenses under a single section. Most of the time, they have been divided in form of various subsections or clauses, and at times, they are not actually enumerated in form of subsection or clauses. Like we'll see even in the BNS, this section 106, subsection 1, which corresponds roughly to the section 304A of Indian Penal Code. there are two offenses, though they are not being enumerated in form of clause 1 or clause 2, just a paragraph or just a sentence separating one offense from the other. So number of offenses, this is quite obvious, can be rather bound to be different from a number of sections. Those are different, separate individual concepts. So here in the IPC, we have got 483 number of total offenses, and under BNS, this number gets reduced approximately by 3%, and this comes to 467. So we'll have total number of 467 offenses in our Sanhita, Nyaya Sanhita. Cognizable or non-cognizable offenses. Here is the number. Red color is used by us, figures and details for old. Red, lal jhandi, red flag, red signal. They are going, and green is new. So 314 is IPC, number of cognizable offenses. 297 is here in BNS. Number of cognizable offenses is similar in both these acts. 147 each. Number of bailable offenses 264 and 255 respectively. Number of non-bailable offenses 205 and 196 respectively. Here we can see under this asterisk mark, this in 23 offenses it is classified according as offense abated is cognizable or non-cognizable, etc. So these numbers, as we are aware, these comes from not the substantive law, not in the IPC or Nyaya Sanhita. These are there found in the first schedule of respective procedure codes, that is CRPC and Nagarik Suraksha Sanhita. So first schedule, there are written under classification heads various, like cognizable, many offenses, this cognizability issue is variable. So there, this is written according as offense abated or this, etc. Similarly, this bailability issue is also variable under certain offenses. Regarding certain offenses, there is written according as offense abated is bailable or non-bailable, etc. And similarly, tribal by what court, that is also regarding many offenses, that is also variable. By what court tribal? So 39 offenses are there classified like court by which offense abated is tribal, etc. Number of offenses tribal by court of session 105 in IPC and 118 in BNS. So now we can start feeling heat. Now till now this was number is larger in the IPC and a bit smaller in the 3% absolute number in the BNS, but now we can see that workload of learned session courts is going to be increased, and by great percentage in terms of percentage, 105 to 118, so approximately 11-12% increase in the number of offenses which are going to be triable by court of session. Magistrate of the first class trend is okay, decreasing 171.44, and any magistrate also. But session courts workload is going to be increased. That means, that suggests that our Sanhita, new Sanhita, in comparison to code IPC, this is towards more serious. We are going to take more offenses more seriously regarding tribal by what court. More heinous offenses are being tried by higher court in the hierarchy of court structure. So this is the case in the cases offenses triable by the learned court of session. So there is another comparative statistics data we have tried to call out. This is compoundable, number of offenses compoundable by parties on their own. We are aware that these provisions are found in the procedural law, not in the substantive law. So section 320 of Criminal Procedure Code, corresponding section here in the Bharatiya Nagarik Suraksha Sanhita is section 359. So these provide this important piece of information. So there is not much difference. You can see on this slide that only difference is there that number of offenses compoundable by parties on their own, this number going to be decreased by single one. This will be 42 in place of 43 in the IPC. So there is only one offense which has been reduced. Otherwise, there is no difference there between section 320 of CRPC and corresponding section of 359 of BNSS. So this difference is due to this fact that one section of IPC, that is section 497 of IPC, which comes under this category, compoundable by parties on their own, that has been excluded as an offense. We are going to see in the subsequent slides in the later part of this presentation, this session, that 497, section 497, adultery, that has been excluded altogether. So due to this fact, this number is reduced by only 1, 43 to 42. Other, there is no change. And of course, the offenses which are not clearly given under the table by that particular subsection 9 of those respective sections of procedural codes, that is 320 CRPC and 359 BNSS, that last subsection provides that other offenses which are not here, residual, every other offense is non-compoundable. So remaining offenses are non-compoundable. Indian Penal Code 427 and Bharatiya Nyaya Sanhita 412. Number of cognizable offenses punishable with imprisonment for a term less than 7 years or which may extend to 7 years. Learned respected officers, how this particular category of offenses is important for our purposes. This imprisonment for a term less than 7 years or which may extend to 7 years. Pardon? Arrest. Yes. Yes. Anyone? Those particular sections? Those particular sections? No, that is some twist there. But this particular, yes, of course, this is related to law of arrest, of course. And specifically, this is power of police to arrest without warrant. That part is dealt with by under section 41 and 41A, Criminal Procedure Code. So after those amendments in the year by those acts, 41 of 2009, 5 of 2009 and 41 of 2010, and WEF 1st November 2010 and 2nd November 2010. Those reforms in the law of arrest, power of police to arrest without warrant. So those provisions, appearance, notice, and there was a major case law, Arnesh Kumar versus State of Bihar, and subsequently followed by other Supreme Court, Honorable Apex Court judgments, like most recent were Satyendra Kumar and Till versus CBI. So many other judgments also, wherever this arresting issue by police under offenses falling under this particular category, up to 7 years or less than 7 years, So this is very important provision, and here कुछ इसका चिलिंग इफेक्ट थर्मोस्टेट थोड़ा सा 1-2 डिग्री ऊपर किया जा सकता है. मुझे थोड़ा सा इसका with due permission from other participants, 1-2 degree, even 1-2 degree will help, may help. So thank you. So section 41 and 41A of CRPC in toto has been reproduced under Nagarik Suraksha Sanhita section 35, to be precise, from subsection 1 to subsection 6. In addition to that, subsection 7 has been added there in the BNSS. My dear colleague Rajsekharan will cover that in his session, and that is to further protect accused from arbitrary arrest on part of police. So there they have provided that where the offense is punishable for the imprisonment less than 3 years and the accused is infirm or more than 60 years of age, then without prior permission of officer not below the rank of deputy superintendent of police, IO or officer in charge won't arrest such person. So that is 35 subsection 7, and 35 subsection 1 to subsection 6 is in toto reproduction of section 41 plus 41A of the Criminal Procedure Code. So this particular category deals with such kind of offenses. IPC number of such offenses is 199, while in BNS this number is 174. Next category of certain data here produced by us is offenses punishable with imprisonment for a term of 7 years or more than 7 years. So this was not of much significance in this existing set of laws. But as I have mentioned in the earlier session, that section 176 subsection 3 of Nagarik Suraksha Sanhita provides that under this particular category, where offenses are punishable for a term of 7 years or more than 7 years, that forensic scientist, forensic expert visit to the scene of crime, etc., and to contribute to this scientific investigation is going to be mandatory. Of course, 5 years grace period has been given to prepare respective states themselves on infrastructure point of view, etc. So number of such offenses is huge. Again, 117 offenses will be covered under this particular category. Number of offenses punishable with imprisonment for a term of 10 years or more than 10 years. So learned respected participants, this as I have discussed it in the during previous session, this category is going to be very important. Apart from existing provisions under the procedure code, there are new provisions which are going to make this category very important. This is the most heinous offense category of our system. And under this, as I have discussed earlier, this proclaimed offender provision is there, which has been expanded vastly, and a bit has been discussed earlier in that session. Subsection 4 of Nagarik Suraksha Sanhita section 84 is going to expand it up to all the offenses, not merely some certain section mentioned in the CRPC, subsection 4 of 82. Unlike that, now this particular category by this particular provision is going to be covered under proclaimed offenders, and that proclaimed offender will be liable to trial in absentia, section 356 BNSS. So this category is going to be very important, and as we can see, this an indication that to this category number of offenses has been increased by more than 10% from 76 in the IPC to 85 in the BNS. There is this substantive increase, more than 10-11% increase under this provision, and combined with those enabling provisions in the procedural code, Nagarik Suraksha Sanhita, we are going to feel the impact of these new provisions in upcoming years. Number of offenses punishable with imprisonment for life or death penalty. This number from IPC 72 has been increased to 78 in the BNS. Number of offenses punishable with death sentence. This category, this ultimate punishment, this number is in the IPC 13, and here 3 increased 16. So one may be curious that where these 3 capital punishment provisions have been increased. So let us discuss it in brief here. Then maybe some of them we may encounter in this later part of this presentation. So these all 3 new addition have got this murder element in there. Apart from murder element, only that death penalty provision here in our jurisprudence is where we have discussed gang rape upon victim of below certain age. This is in the IPC. This is 376 DB, where if the victim girl is of less than 12 years of age, we can punish them with the death penalty. And this will be under section 70 subsection 2 of BNS. This age has been increased, so this scope has been expanded hugely. So below 18 years. So there is a non-murder element, still capital punishment is there. Otherwise, this capital punishment is mostly under this universal, this jurisprudence. This is not in the cases where that accused has not murdered someone or that element of murder. So that is a rare exception, that gang rape. So here also, these 3 newly added provisions responsible for that punishment up to death penalty are having murder element in all of them. So these are first 103 subsection 2, that is mob lynching related. Mob lynching, though that is not a legal term, not a statutory term, never used anywhere. That is 5 or more persons on ground of certain this, so and so. So that is there is murder term is used. So element of murder is directly there. That is enlisted also there under that murder section only. That corresponding section of 302 IPC here in the BNS is 103 subsection 1, and next subsection 2 deals with this newly added offense, that is common parlance, that is called mob lynching. So number 1. Number 2, organized crime where death also is there committed. So section 111, particular subsection which is dealing with the organized crime resulting in some death, murder. So that is also covered. So 2. And third one is terrorist act, covered under section 113, particular subsection where during that terrorist act some one gets murdered also, there is also. So 3 these death penalty punishments. So there in under this this particular list, hyperlink is there. This we have tried to, though due to paucity of time, after lunch also we have this session of BNS, so we can go through this list. We, dear participants, you don't find in any book published by major publications there which deals with this in a tabular form there with summary of comparison. There in detail, you need to go inside that. But here we have provided this summary of comparison to help reader that if we have not that sufficient time to go through whole the text, we can, by going through this table, although this is a huge code, huge Sanhita, so this table also runs in many dozens of pages. But here we can have a feel of those changes, what sort of changes have incurred there from IPC to BNS. So this is first column, this is BNS section, next column subject, and next column IPC section, and the last rightmost column is summary of comparison. So these we have tried to deal with, and I will make this presentation available to learned director Sahab, academy, so that they can further disseminate it between learned participants. So like first section, that is short title commencement and application. So there are formal changes in every subsection, but the original meaning is intact. Heading of subsection are not there in BNS. Section 1 of BNS is related to the date when the BNS will come into force. 6 subsections under section 1 of BNS corresponding to 5 separate sections of IPC. Here this subsection 2 also, there this was not written that this executive may appoint this date of commencement. Here this is there in our BNS. Punishment, no change except code is replaced with Sanhita. As I mentioned, so code is replaced with Sanhita everywhere it is mentioned. So this is formal change. It doesn't change any meaning. Though there may be no other change in a particular section, but if the mention of some code, either of Bharatiya Nyaya Sanhita itself or BNSS, Nagarik Suraksha Sanhita, so this is written Sanhita. Punishment of offences committed beyond which by law may be tried within India. So there is section is included as subsection in BNS sense heading, where whole individual sections have been included in Nyaya Sanhita. So by that scheme itself, there is limitation when we are consolidating so many sections under a particular section in form of subsection. So they cannot give under subsection every heading of every individual section. So this is the limitation. We are talking about that. Like subsection 5, section is included as subsection in BNS sense heading. In the illustration, Uganda has been replaced with any place outside India. So this is again very formal nature change. This doesn't change substantially anything of that particular provision, but these are certain changes. Next is subsection sense heading without heading. Definition, as I mentioned earlier, definition section, so many sections, section 8 to 52A, categorized under chapter 2, general explanations. All of these sections have been here enlisted in under a single consolidated section 2, definition section, subsection 1 to subsection 39. So here we can see some of them. Act here, which is there in the IPC 33, section 33. Here it is in the form of subsection 1 of definition section 2. Here these have been enumerated in alphabetical order. So this is greatly convenient to us to find certain definition section, go through that. So that will that is arranged in the alphabetical order. Like subsection 1 is dealing with the act, next animal, next child. Definition of child has been newly added. There is no definition of child found in the IPC, but here under section 2, subsection 3, This is child, any person below the age of 18 years. This is a new addition under definition section. Other are same, no change. Some like court, definition of court, which is there in the section 20 of IPC. Here, this is found under subsection 5 of definition section 2. Here, BNS Act excluded the illustration and the use the word court in place of the word court of justice. So in the IPC, we have been using this court of justice phrase. Here in the BNS, this is described by only single word court. Next, death, no change. Whoever does is excluded. What's is said to do that thing dishonestly. So these are only formal changes. These are not necessarily changing anything in the meaning or purport of that provision, but these are like whoever does is replaced by words it's said to do that thing dishonestly, like this. So similarly, here document, this is important addition because under this definition of document, which is given in the IPC, section 29 and 29A. 29A was added when IT Act was enacted, Information Technology Act in the year 2000. So this was added, but further these words and includes electronic and digital record are added. Fraudulently, phraseology changed, but essence is same. Gender. Definition of gender is there in the IPC under section 8. This is here under 210. Here transgender is added apart from genders of male and female. Good faith, no change. Government of a state is replaced by state government. So again, formal change, no change in essence. Harbor, except in section 157 and in section 130, in the case in which the harbor is given by the wife or husband of the person harbored, the word spouse has been excluded. Husband of the person harbored, these words have been excluded. Word denotes is replaced with means. So denotes and means, there is no change in the meaning, but denotes maybe thinking that this is an archaic use, so that is replaced with means. Illegal and legality bound to do, no change. Life denotes is replaced with means. Local law, no change. Man, word denotes is replaced with means. IPC section 10, man, woman, they are placed in a single under a single section, definition 10. But now here in the BNS, these have been dealt with differently. Under different subsections. British calendar is replaced by Gregorian calendar. So term British calendar is replaced by Gregorian calendar. So British and Gregorian, of course, that is one historical aspect of history of calendar in the Europe. So there was two sort of sets, Gregorian calendar, and another one is any student of history or by any other. So another competitive calendar there in the Europe used to be, there was a competition between these. So some nations used to use this and that. Then finally, in a particular historical period, this Gregorian calendar was adapted universally by the Vatican City also. So whole of the Christian world, and by their impact, universally that was accepted. So competitive, another calendar was Julian calendar. So Julian versus Gregorian, there was this thing between these two competition. And British calendar, this Protestant church, British church, they had this third view of their own, and they used to use this British calendar also. So term was this British calendar there is still written, though practically for long, 18th century onwards, we were already using this Gregorian calendar for all practical purposes. So that this term has been replaced. This has got this symbolic meaning, movable property. This is important provision, important addition, important expansion under definition section. So this we may like to notice, take note of more seriously, that we have removed under BNS, we have removed this adjective corporeal. So by removing this adjective corporeal, this whole scope of this movable property expands limitlessly. So intangible things, like these days we are going towards paperless currency, everything. This is in the digital form, intangible way. So to include all those new developments of human civilization, new achievements, technological and in the economics or commerce, everything. So to adapt to that situation, to make it contemporary, this adjective corporeal before that property has been removed. So this has got great purport. Again, this oath related court of justice words have been replaced by a single word court. Acts and omissions in the IPC, they are defined in under a single individual section. Here they have been dealt with separate different subsections. Though interestingly, these are not in essence defined per se in these laws. What is a certain act in that form? They, in fact, series of acts will be considered as a act. They provide like this manner. So there is no change under this in this situation. So again, a special law that a formal change is replaced by means. So this is formal change, not any essential change. Wrongful gain, no, that is also formal change. Gaining wrongfully, losing wrongfully, no change at all. Words and expressions used but not defined. So this is very important. This is last provision of definition section, last subsection of definition section. So here residual things have been covered by providing that this scope of section 29A IPC is broadened as for words and expressions used in BNS but not defined in BNS but defined in the IT Act 2000 and Bharatiya Nagarik Suraksha Sanhita 2023 shall have the meaning respectively assigned to them in that Act and Sanhita. This has been expressly written. So that there is no doubt whatsoever left. General explanations. So these have been excluded under subsections. So this is subsection 3, property, possession of wife, clerk or servant. So this wife, this term has been replaced by spouse by making this in this manner gender neutral. So these are incorporated in form of subsections, sans heading, without heading. So there is no change in essence, only reorganization. Punishment. This is important and we'll deal with later part of this session also. This punishment under provision section of punishment, IPC section 53 deals with this provision. Here section 4 deals with punishments. So subsection F, 4F, that is newly added, which provides community service. Community service as a new form of punishment under the Sanhita, main penal provision, or we say like here Nyaya Sanhita, justice. So where are community service earlier we have encountered with? Kindly learned participants may like to recall. Pardon? Yes, correct. Thank you. Anyone can recall that particular section? So that is again, JJ Act is a huge act. So 100 plus sections are there. So it is not easy to remember some section. So that is section 18C, JJ Act. JJ Act 2015. And there is another provision where community service has been introduced in our jurisprudence. Where it is? As far as I could gather, maybe some other provision I am not aware of, but at least there is one provision where community service is already there before this 2023 enactment. Anyone? Pardon? Where is that? This is a guess, a smart guess though. Okay. So community service is there in after 2019 amendment in the Motor Vehicles Act. So though they have provided both definition also under section 4A and under section 200, if that person fails to pay fine, then community service can also be a form of extracting that. So apart from these two provisions, I'm not aware about third or fourth provisions. Maybe there, Hughes law, maybe somewhere else, this may be there, but I'm not sure. So community service, but here under BNS that has not been defined, though that has been mentioned under section 4F as a newly added form of punishment, but it is not defined here under section 4 punishment itself. Rather, we find it there under that procedural code, that is Nagarik Suraksha Sanhita, section 23, where they define this power of magistrates to sentencing power of magistrates. Under that heading, under section 23 of BNSS, Nagarik Suraksha Sanhita, they have provided under form of explanation, not in form of definition specifically, but that is all the same. The purport is all the same. They have explained their community service. So community service court may order the convict to serve in the interest of community certain things for which remuneration is not paid. So community service, this is there, and there is a separate slide also dealing with community service, where we'll discuss what offenses have been provided as alternate punishment or standalone punishment, this particular type of punishment. Commutation of sentence. So commutation of sentence provision has got some changes, formal changes, but cross reference is given of BNSS, which is not in the IPC. Fraction of terms of punishment. So there is not also any change. This is already under section 57, that where we have to deal with fraction of punishment under certain requirement, then we'll take life imprisonment as 20 years to calculate that fraction of punishment. So there is no change in under this provision, 57 IPC and 6 BNS. Amount of fine liability in default of payment of fine, etc. Here this amount of fine has been increased here. IPC section is included as subsection in BNS sense heading. In default of community service is added because this is newly added provision. So we had to amend, accordingly modify this respective section that is here dealt with in subsection 4 under section 8. So we may, Court of Justice again, no change act done. So these are act of person of unsound mind, no change, incapable of judgment by reason, intoxicated, no change. These general exceptions, most of these sections have been unchanged, remain unchanged. Act done in good faith for benefit of child or person by or by consent of guardian. Words insane person is replaced with person of unsound mind. So this is again of a formal nature only. So such changes have been there also. Somewhere firstly, secondly, thirdly, like section 38, fourthly, fifthly, etc. are replaced with A, B, C, D, E, F, G, etc. So these are mere formal changes, symbolic change. These these changes don't make any essential change in the meaning or purport of or scope of that particular thing. No change. Right of private defense of property extends to causing death. So by night is replaced by after sunset and before sunrise. So by night a vague term has been more particularly specified in this form. Mischief by fire is replaced by mischief by fire or any explosive substance. So any explosive substance has been added under this provision, section 41. This is regarding right of private defense. So other subsequent section, these don't have any substantive change. So we'll discuss where some changes there. Otherwise, these are formal change or no change. 62, no change. Rape definition. Rape definition, IPC section 375. Here, BNS 63. So let us discuss change which is there. Age of consent, 15 years, is replaced by 18 years in BNS exception 2, which deals with husband, sexual intercourse or acts by a man with his wife. So the wife not being under 18 years of age. Now this 15 has been changed, which is made to 18. Now there was a discrepancy. Now child marriage prohibition acts are there. Those provisions are there. Under 18 years marriage is not a marriage. So now with this these changes, this some discrepancy was there in between that statute special act and under this particular definition. When that is not something is not valid there, then why should this exception should be given here? Due to this thought of process, this change has been made. So in place of under 15 years of age, this has been made it under 18 years of age. Otherwise, there is no difference. So other provisions are all the same, 375, with those subsequent amendments inserted through Criminal Law Amendment Act 2013, one of the most important act in the history of jurisprudential development in our nation regarding offenses against woman and child. So punishment of rape for word military is replaced with army. Certain, this is section here 64. Other things are formal changes. So next, gang rape. Gang rape 70 subsection 2. We have already discussed that 376 DB part under 12 year of age, that maximum punishment possible, capital punishment, is now will be available with the victim below 18 years of age. So this is 70 subsection 2. Minor is replaced by child, word minor. So this is again formal nature. 73 section corresponds to 228A 3, 354, 74 without any change. Any words, any man who is replaced by whoever. Assault or use of criminal force to woman with intent to disrobe. So any man who is replaced by whoever. By this change, this has been made gender neutral on part of the offender. Offender, if some woman also try to use criminal force on woman with intent to disrobe, that woman also can be booked under those provisions. So this has been made gender neutral. Voyeurism also made gender neutral. There, any man who is replaced by whoever under that provision also, which deals with dealt with by 354C IPC, here 77. Enticing or taking away or detaining with criminal intent a woman, married woman, words from that man or from any person having the care of her on behalf of that man are excluded. 498A, Section 498A IPC has been bifurcated into two independent sections here, BNS, Section 85 and Section 86. Under Section 86, cruelty is defined, and before defining that, already under Section 85, penal provisions are there without any change. So there is a already 2011 or 12 case, Preeti Gupta versus State of Jharkhand. Now there is on the 3rd May of this year only, Achin Gupta versus State of Haryana. There has been a case law by a division bench of Honorable Apex Court, who have urged that legislature should take a relook into these provisions, earlier 498A and now 85 and 86. So there is those case laws. They have requested legislature officially, Honorable Apex Court, through the registry of Honorable Apex Court, that legislature may have a relook into certain issues. So causing miscarriage defined in last so this is again preceding, formal change. So minor girl under the age of 18 years is replaced by word child in the Section 96, procuration of child. So this is made again gender neutral on part of victim, on side of victim. And this Section 95, hiring, employing or engaging a child to commit an offense. This is a new addition, as I have already discussed under that previous session. And this Section 69, we somehow, I skipped this sexual intercourse by employing deceitful means. This is a newly added section, as we have earlier discussed, on pretense of marriage or by promise of employment or promotion or by concealing identity, etc. So this was there. This is there. Uh, 99, buying minor for purposes of prostitution. Minimum mandatory punishment is introduced at 7 years and upper limit of imprisonment is extended up to 14 years. These enhancement in punishment, etc., and mandatory minimum punishment introduction, we'll later in the part of presentation, we'll discuss in separate slides. There, those under what provisions these things have been dealt with. Section 101, definition of murder. Section 100, culpable homicide, without any change from respective sections. If there is any change, that is only formal, like 300 murder, here, there, firstly, secondly, thirdly, here, this has been enlisted in form of Roman lowercase a, b, c, d, etc. So there is no substantial change, no change in essence. 1032, punishment for murder by 5 or more persons on ground of race, caste, or community. We have already talked about that, discussed that. Mob lynching, known in common parlance. But in this small a couple of months itself, there is a certain evolution, some history legally, as these first draft bills were introduced in the Parliament in the month of August 2023, and immediately after that, those draft bills were handed over to department-related Parliamentary Standing Committee of Home Affairs. Chairperson of that committee is ex-retired IPS officer, retired as DGP of Uttar Pradesh, Mr. Brajlal. He was heading that committee, and that honorable committee submitted its report on 10th of November 2023. Thereafter, government withdrew those first set of draft bills and reintroduced that after considering that report, which is known to be as 246 report of that standing committee. So those one of those recommendations which has been incorporated by the government in the subsequent second draft of bills, which is in form of enacted law before us. One of those recommendations which was honored by the government and subsequently passed by legislature is this also regarding this mob lynching provision. So what happened, this caste or community word is also being added after that recommendation, and there the punishment part in the first draft bills, this punishment was proposed to be death penalty, then life imprisonment, and imprisonment not less than 7 years. So there were deliberations that this third alternate punishment should not be there, because this is a murder, and murder, this punishment for a murder should be at par with murder. No third alternate some lesser punishment option should be there. So this was the deliberation by of honorable members of that honorable committee. So that committee recommended that this punishment for this particular offense, though this is a very welcome addition by the government proposed, but this punishment should be made at par with that of the murder. So that's how we are having this in present form, that punishment for this particular provision is at par with murder now, death penalty and life imprisonment. So I think with the due permission of learned director साहब, maybe we can have क्या सर लंच ब्रेक के लिए, बिकॉज 1:15 हो गया है उसके बाद में, तो रिमेनिंग जो भी BNS का है तो पोस्ट लंच, व्हाट इज योर, this is next session is also BNS, so remaining things we'll cover in the next session, and some officer may be quite particular about taking their lunch on time, so maybe what is as you instruct. So far we whatever we have discussed so far, any questions please? Remaining things we will discuss later post lunch session. Any queries?
Sir, please throw light. So far the death by negligence, now it is 106, that has not been come into force. That has not been brought into force. 106, death by negligence. Earlier 304A.
Okay. So
what will be the position if after 1st July?
Yes, I am telling you. This section is there 106. This has got 2 subsections. Subsection 1 exactly, in toto covers 304A with some additions. 304A, death due to rash and negligent act, 304A IPC is incorporated here under section 106 subsection 1. This is there, recent, and although this has been taken more seriously, so punishment has been enhanced from maximum punishment extendable up to 2 years of imprisonment under section 304A IPC Now this will be up to 5 years. And simultaneously, one additional offense is also there. Later clause of subsection 1. When we'll discuss this later slide in new addition, then we'll see that also. So there they have expressly covered registered medical practitioners also. So 304A is there with harsher enhanced punishment up to 5 years in place of 2 years, and registered medical practitioners for them, that is a separate offense, and that they have been a bit lenient, and their punishment scheme is exactly as that is 304A up to 2 years. And subsection 2, again, this was a new provision which has been kept on hold. Exception 1062, that is hit and run thing, which someone runs down some vehicle, someone, and runs away without reporting it to police or magistrate, then that offense is 1062. That was protested against by many organizations, driver association, etc., and transporters. So that has been kept on hold. And that 304A is there with enhanced punishment. An additional clear provision to book those registered medical practitioners. Otherwise, they were all booked under section 304A proper without with some stretching. So that their advantage was to accuse, though certain case laws defined that where that will be applicable, like gross negligence and all, those phrases were developed by honorable constitutional courts, but there was no clear provision as such.
So now what option is left to us to know that under what provision?
1061 is there.
Only it will cover 1061, even if it is a death by negligence or by death by accident.
Yes, both 1061, and if that negligence is caused by registered medical practitioner, 1061 later clause.
Yes, no, accident. I'm saying
1061
vehicular
simpliciter.
Also, it will also include.
Yes, 1061 simpliciter.
Okay, thank you.
Sir, 304A in BNS is made non-bailable offense.
On that part, this is not the case. Let me clearly, read it out, these provisions with the that has not been made non-bailable. This is classification change is not there. That is still bailable, but this punishment has been enhanced up to 5 years. Let me read it out. 1061 completely. This corresponds to IPC 304A, as I have already mentioned. This is written: whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 5 years. In IPC, this is 2 years, or years, and shall also be liable to fine. In the IPC, this is or with fine or with both. Here it is up to 2 years and shall also be liable to fine. So there is enhancement of punishment on both sides, upper limit of imprisonment, plus this is fine is in addition to, this is not as an alternate punishment fine, rather, and shall also be liable to fine. And if such act is done by a registered medical practitioner, this is later clause I was talking about without defining it, rather later part of sentence itself. So clause there, it can be taken in a grammatical form, not in a particular entity in legal terms. So done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. So this is the whole provision, one paragraph, and in a single sentence. This whole provision in a single sentence, it covers this enhanced punishment and this newly added offense relating to registered medical practitioner. Here, again, explanation is given to explain about registered medical. For the purposes of this subsection, registered medical practitioner means a medical practitioner who possesses any medical qualification recognized under the National Medical Commission Act 2019, that is Act 30 of 2019, and whose name has been entered in the National Medical Register or a state medical register under that act. So this is whole this 1061, and so everything which were covered by 304A IPC have been covered here clearly with certain changes, enhanced punishment mostly, and this registered medical practice. And what is kept on hold is subsection 2. Let me read it out also. This is whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide, comma, and escapes without reporting it to a police officer or a magistrate soon after the incident, comma, shall be punished with imprisonment of either description of a term which may extend to 10 years and shall also be liable to fine. So this part, this subsection 2 has been kept on hold. This is known as, in common parlance, hit and run cases, hit and run. So this has been kept on hold. So this is still bailable. This has not been made non-bailable. There is no change in classification per se defined given in the first schedule of respective code and Sanhita, but this is the case. Thank you.
Thank you, sir, for your deliberation with regard to the Bharatiya Nyaya Samhita overview and comparison. We'll commence our next session at 2:15 p.m. after the lunch. All the participants are requested to take their lunch in the dining hall. Thank you.
Thank you. These different sessions have been organized on certain themes as mentioned by learned director sir. But as this pertains to single act, that Bharatiya Nyaya Sanhita, so it may be useful and meaningful that we continue with the discussion regarding this Sanhita, and during that course these things are discussed and we can get ourselves to those specific points, that what is how the challenges have been successfully met by these, up to what extent, etc. Like, so contemporary challenges, as we have already talked about, that we have to upgrade ourselves according to our contemporary needs. That's why these new criminal laws have been enacted in this manner. Technological advancements, and to utilize them, to tap them in the interest of justice administration. That's why all those provisions have been made. So regarding BNS, that is substantive provision law, substantive law. So as we have discussed some points like this mob lynching issue. So for certain recent some years, this issue was widely discussed in the society through media, social media, etc. So the government found it necessary to take up this challenge, and accordingly this provision is being made here. Similarly, offenses related to offenses against women and child, there those provisions have been newly added, like we have discussed section 69, section 95, etc. Some of them being made gender neutral, some from perspective of victim, some from perspective of accused. Those we have discussed. So should we continue with this discussion in this format only, that discussing this each and every, wherever there are changes, going in this sequence, summary of comparison, etc.? What is the opinion of House? Silence. Should we go about this with discussing these things in this sequence, or what would you like to? Pardon? We may continue with this. Okay. In that due course, those specific things are being discussed. And I would like to urge you that this may be more participative, because from your part, this is certain sessions learning like this cannot be one way flow of information or whatever. This, every one of us present here in this house has got maybe certain unique things to contribute. We have got our own experiences, maybe our own insights, our own certain queries also, certain suggestions also, some contribution. So kindly you may be more participative to make this exercise more fruitful and more meaningful. So let us continue with this discussion. So we were somewhere 106 and all, section number 106 we were discussing. So to complete that discussion, though this newly added section 106 subsection 2 has been kept on hold, but that doesn't mean that we lawmakers have subtracted anything which already existed. No. Subsection 1 of section 106 is even still, without 106(2), still it is a bit more than 304A IPC. More in term, higher. This is 5 years, as I said. And registered medical practitioner as a different category as of offender, a different offense with different penal provision has been already made within that single sentence subsection, as I read it out in the earlier session. So there is nothing taken out of existing 304A. Still it is far more progressive and evolutionary, incremental in the direction of that evolution. So 106(2) was important because there was certain caveat was added without informing. So lawmakers wanted that our every citizen may be more responsible, more sensitive to the requirement. Had that person reported timely, maybe some good quality medical aid is available to those injured. So, but that due to various reasons, because we are not, we were discussing with Misra Sahab informally after that certain incident in that state where I work, my cadre is Bihar. So way back, maybe 10 or 15 years back, but such instances, such mishappening, such thing is not unheard of from other parts of India also. Maybe not up to that grave, that dimension. What happened in a road accident case? After those nearby villagers, they assembled on the national highway and made this traffic jam. And in between, some person, one family coming from one side on the highway. During that jam, those villagers, that violent, bloody mob, that burnt one whole family alive of passers-by. They are not driver or they are not culprit. They were not even responsible for that accident. So such things, completely innocent people may get killed by such unruly mob. So many parts of our nation, law and order or their civic sense or their sensitivity is not that good. So that law-abiding driver maybe he was at fault or not, that on road accident he hit someone. Okay, he reported some police officer or some informant. He has to he has to be there, and in the meantime these certain mob may kill him or her. So these are realistic concerns. So maybe after those protests, those things were conveyed to those competent authorities, and they took this decision to, for timing, keep it on hold. So there are things are not as simple; they are complicated. So, but this section already 1061 has has achieved certain things in comparison to 304A. Though this may be disappointing to many of us, maybe that this is not still made non-available. This is still available, but there must be a thought process behind it, because not necessarily from very beginning this is obvious that who was at fault or not. So maybe due to certain reasons this has been made available, but punishment has been definitely enhanced. So let us move to next provisions. Organized crime, as we discussed, organized crime is a newly added section, and there are various new offenses. This is not a single offense under this head, organized crime section. There are many separate offenses defined and penal provision accordingly made. So these are the offenses. Section 130. Organized crime, section 111. Would you like me to read out this first definitive provision, which is dealing with this? Should I? So this is subsection 1 of section 111. Any continuing unlawful activity. Continuing unlawful activity. So many phrases here are very important under this particular definition of 111, which need to be considered. Any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offenses, cyber crimes, trafficking of persons, drugs, weapons or illicit goods or services, human trafficking for prostitution or ransom, comma, by any person or a group of person acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate, by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute organized crime. Further explanation, under explanation, they have defined certain terms. Organized crime syndicate means a group of two or more persons who, acting either singly or jointly as a syndicate or gang, indulge in any continuing unlawful activity. Then next is continuing unlawful activity means an activity prohibited by law, which is a cognizable offense punishable with imprisonment of 3 years or more, undertaken by any person either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offense and includes economic offense. So this is regarding continuing unlawful activity. Economic offense is again explained over here in the next clause. So this is organized crime definition subsection. Then under next section, if such offense has resulted in the death of any person, be punished with death or imprisonment for life, and shall also be liable to fine, which shall not be less than 10 lakhs of rupees. When death is death of any person has resulted during this course, so this is additional. We were discussing death penalty. So this is here 111 section subsection 2. Here it comes. Then in the next subsection, next clause, in other case, be punished with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life, and shall also be liable to fine, which shall not be less than 5 lakh rupees. And further, some other offenses are also defined and penalized under subsequent subsections. So this is organized crime, and this is we are much aware that organized crime menaces so telling and so compelling that some states already for many years they had to enact their separate special acts to curb this menace. Like one of them most famous is Makoka, Maharashtra Control of Organized Crimes Act, or like so. But lawmakers thought it necessary to take these such provisions in the main Sanhita. That's why we are going to have this provision of organized crime. Then next provision is also there, that is petty organized crime. Petty organized crime, they say, subsection 1 is definition section. Whoever, being a member of a group or gang, either singly or jointly, commits any act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, selling of public examination question papers, or any other similar criminal act, is said to commit petty organized crime. So this is another new section, and penal provision for this is imprisonment for a term which shall not be less than 1 year, but which may extend to 7 years, and shall also be liable to fine. So this is petty organized crime. And subsequent section also, that is also new, that is 113, Terrorist Act. So Terrorist Act is in addition to already we have, as we are aware, there is a special act known as Unlawful Activities Prevention Act 1967, UAPA. So UAPA how many of learned officer present here have dealt with UAPA? None of. Okay. So UAPA is there, and after subsequent amendments, that is quite a strong an act. But our lawmakers found it necessary that this provision should be taken here in the Sanhita also. That's why this section 113 is there, and there are so many offenses defined and penalized over here. And generally speaking, these offenses have been taken with certain modification in the language, etc., from UAPA. Section 16 onwards, there are offenses, penal provisions are there in the UAPA Act. So, section 113, subsection 2A, Roman lowercase, this corresponds to UAPA section 16, terrorist act resulting in the death of any person. And this punishment is similar there and here in the section, in this section. Similarly, B, Roman lowercase b of this very section and subsection in any other case. So we have already read it out that 5 years and all. Subsection 3 also, conspiring, attempting, abetting, etc., or knowingly facilitating the commission of terrorist act. So there is also this provision. This in the UAPA, this is section 18. Here, this is subsection 3 of section 113. So similarly provided here under section 113. So a couple of offenses have not been included from UAPA. They are exclusively under UAPA only. But most of the offenses provided under UAPA have been taken here in this different form of different subsections of this section. And to clear doubt, they have provided an explanation in the end of this section. They say, for the removal of doubts, it is hereby declared that officer not below the rank of superintendent of police shall decide whether to register the case under this section or under the Unlawful Activities Prevention Act 37 of 1967. So this explanation is provided here. An officer not below the rank of superintendent of police has been empowered to take decision whether particular incident in hand is going to be registered under this section or under that special act. So this is 113, and due to this terrorist activities threat from so many players, international or internal, our lawmakers found it expedient to take this provision newly added in the Bharatiya Nyaya Sanhita to deal with such situation. So you can see in this table that there are other next addition in that in this scheme is voluntarily causing grievous hurt related section 117. There are new additions. These are 117 subsection 3. This suggests this reads, whoever commits an offense under subsection 1 and in the course of such commission causes any hurt to a person which causes that person to be in permanent disability or persistent vegetative state shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life. So this is a very strong provision made where such hurt causes that victim to certain permanent disability or persistent vegetative state. Next subsection also is added here in Sanhita that deals with similar situation as that is regarding mob lynching scenario. If the certain victim is fortunate enough not to get killed under such violence, under the incident of such violence, but unfortunate to sustain grievous hurt, then that is covered under this subsection newly added. So other offenses against human body, there are not much changes. We can see there are corresponding, just sections have been changed. Most of the text is reproduced with maybe somewhere with formal changes in phraseology, etc. And we'll discuss later where these imprisonment and fine have enhanced or minimum threshold of punishment has been introduced. So we can move here fast in a. So there is one important change in Sanhita, that is more of a structural change, rather substantive. That is in the IPC, these coins and currency related offenses are numerous. So those are around 30 offenses. So out of those 30, section 236 is excluded, and other 29 have been covered under Nyaya Sanhita within 4 sections only. So they have drafted it so carefully and precisely that those concerns addressed under those 29 sections of Indian Penal Code have been dealt with within these 4 consolidated sections. These sections starts from section 178 and up to 181. So another change we skip through here, that is section 152 Indian BNS, that is to tackle concern related to sovereignty, integrity, unity, security of India. As we are going to exclude, we have excluded section 124A to take care of those concerns. Section 152 is newly added, and section 197 subsection 1 clause D is also newly added. This particular section corresponds to section 153B of IPC. Here, making or publishing false or misleading information jeopardizing the sovereignty, unity, and integrity or security of India. So this is a new offense added to take this particular aspect. So now we can go to next slide, getting out of this hyperlink, which is dealing with summary comparison. We can go to some specific slides. There are 24 offenses where mandatory minimum punishment in terms of imprisonment has been added. ये हाइपरलिंक नहीं खोल रहा. some problem maybe. So 24, in 24 instances, offenses here under BNS, these mandatory minimum punishment, lower side of punishment in terms of imprisonment has been added. Out of 24, 13 are completely new addition as offense like organized crime and terrorist act related offenses, and 11 are those offenses which already exist in IPC, but their such lower limit of imprisonment does not exist. So 11 and 13, 24 instances, and now under BNS we'll having total number of such offenses where mandatory minimum punishment lower limit is given there. This number will be 45 now. There are 36 offenses with increased imprisonment, where imprisonment in terms of punishment in terms of imprisonment is being increased. This is in 36 offenses. Somehow this I am unable to open this hyperlink. In 84 offenses, fine has been increased either or defined or added. 84 offenses, this has happened. So increased fine amount is very obvious, because for many decades that that amount was not revised, and value of money, value of rupee has been decreased due to inflation, continuous very long period of time. So that increment is obvious, and at some instances this was not already defined that up to this amount. So that is also being defined or added in addition to that imprisonment. Provisions where community service has been introduced as punishment. Thank you. Okay, now we can open this. So this is the list where punishment has been increased in BNS. This is the list of those offenses. Total number is 36 of these offenses. क्या हुआ? Now we can come to community service offense, as we have discussed that under section 4F, this has been added, and there are 6 offenses where this particular offense is added. Section 202 BNS, 209 BNS, and आएंगे थोड़ा इधर मदद करने. हाँ, next is 226, then 303 subsection 2, 355 and 356 defamation. So these 6 offenses, out of these 6, only one offense is there which is cognizable. Otherwise, all 5 other 5 offenses are non-cognizable offenses. This cognizable offense where this community service has been added as an alternate punishment is section 209 BNS. This corresponds to section 174A IPC. Any of us in the house have has this have ever used this this provision 174A? 174A Indian Penal Code? None. So definitely Odisha is not one of those states where this has been used in up to any extent. There are three jurisdictions of Honorable High Courts of Judicature. That is Honorable Chandigarh High Court, Allahabad High Court, and Delhi High Court, where this provision has been used up to certain extent. This is a very important provision inserted through Act 25 of year 2005. These provisions were effective from 23rd of June 2006. And there was another provision added, inserted in the IPC by same Amendment Act. And that is directly related to learned courts. Have you any idea about that section also? Effective from 23rd June 2006, 18 years. 18 years have passed since. So these two insertions by that Act 25 of 2005 are very important to curb this tendency of evading arrest or evading trial, absconding. So by those amendments in the as I have mentioned, 23rd June 2006. One is Section 174A, that is reproduced here with minor changes in form of Section 209. And another is that is directly related, this 174A also directly related with learned courts. But another one is even police comes to know after you only, learned courts. That is Section 229A, Indian Penal Code. Section 229A Indian Penal Code was inserted by Act 25 of 2005, WEF 23rd June 2006. So this is regarding bail jump. If certain accused jumps bail related to your court, there this cognizable offense, these are cognizable offenses. They made deliberately cognizable offenses. Though under Section 229A, there is punishment is of only up to 1 year. But deliberately, lawmakers made that provision non-bailable and cognizable. Cognizable offense. But we failed to all over across the country. Many participants come to academy, and I put this question before everybody, learned judges and learned prosecutors. So almost nowhere we have utilized this provision. 174A to limited extent, as I mentioned, Allahabad High Court, UP, and Punjab, Haryana, and Delhi. Though not other parts of India. I was there in the Bihar, my parent state. So I tried to get an standard operating procedure SOP issued to utilize Section 174A IPC. I tried to convince my DGP, and DGP told me, okay, you prepare draft SOP yourself. So I prepared draft SOP also. And there I mentioned that case law also, Kuldeep Singh versus State of Haryana. This case law, after so many, this Chandigarh High Court Honorable, previously there were many case laws like Sanjay Sareen versus UT of Chandigarh, Iqbal Singh versus State of UP, Moti Singh Sikarwar versus State of UP, Krishna Reddy versus CBI, Delhi High Court, and State versus proclaimed offenders, Delhi High Court, Manish Gumar versus UT NCT Delhi. Like so many cases where learned honorable courts directed that this should be Sanjay Sareen like directed that if police does not file an police do not file an FIR when they are submitting charge sheet with absconding accused, then don't accept such charge sheet. One case, Krishna Reddy versus CBI, Delhi High Court, provided that even this is not necessary that separate case may be registered. Even supplementary charge sheet will do. So these were those honorable case laws. Then honorable High Court case laws. Then I was talking about Kuldeep Singh versus State of Haryana. What happened with Kuldeep Singh? He was absconding. After proclamation, so he defied proclamation order. So he was there. A case was registered against him under Section 174A, and during trial, the learned magistrate convicted him. So he preferred an appeal before Honorable High Court and pleaded that as that original substantive case against me, I have been discharged from. So this is now infructuous. So this whole proceeding may be quashed. So learned High Court Chandigarh, in its judgment, clearly held that no, this offense under Section 174A doesn't has any nexus on merit of that substantive original case against that particular offender. So there is no, we are not bothered about that merit of that particular case. This is independent substantive offense committed by you by defying that particular order under law. So there is clear non-cognizable offense and there is provision of punishment. So learned magistrate has rightly awarded this conviction. So Kuldeep Singh versus State of Haryana. So with all these arguments, I put a draft SOP before my DGP, but after that nothing happened. That is still there. No action was taken by their superior authorities of police headquarters. So there are certain misgivings regarding Section 174A. That certain honorable high courts also taken this view that Section 195 subsection 1 of CRPC, due to that, this should not be taken as a cognizable offense, ignoring very much that this is later insertion in the code, and expressly the lawmakers have provided definite entry in the first schedule of the CRPC, making it cognizable. But still they were taking this plea and all. 195 CRPC. Now, I am discussing this in greater detail because now under these new provisions, we have progressed a bit. Lawmakers have done two things regarding these provisions. Number one, regarding 174A corresponding provision 209, there are some changes regarding first part of that, which is dealt by subsection 1, proclaimed persons. Their punishment, they have added as an alternate punishment even community service. That's why we are discussing it in this slide particularly. So community service, they have been a bit lenient, and community service as an alternate punishment also is being added under section 209. But later part, that proclaimed offender part, subsection 4, procedural code, deals with proclamation against proclaimed offender, that coming under that particular category, BNSS, as we have discussed earlier, that 10 years punishable with 10 years or more, that will be dealt with by subsection 4 of section 84 BNSS. So regarding such accused, such offenders, there is no change in the punishment. That is similar punishment up to 7 years. That is in 174A. So there is no change. But even more important change has been made to clear that doubt, unnecessary controversy which was created against 174A provision that this is not cognizable per se, that was by through this section 195 CRPC, as I have mentioned. So now we have this clear provision under section 215 BNSS, which corresponds to 195 CRPC. They have clearly excluded section 209 BNS from that provision. So I am requesting you, respected learned judges present over here and virtually connected, that kindly now please start utilizing these provisions. Though regarding 229A, there was no such controversy at all. There was no such controversy regarding 229A, but still we failed to use that. If we use 174A, 229A IPC before 1st July till then, or after 1st July, we use 209 and 269. 269 is corresponding section to 229A. Belgium, that is section 269. That is 100% reproduction of section 229A. So if we start using this, I am not aware that in the state of Odisha, how deep this menace is of absconding themselves, absconders keeping themselves absconding, evading arrest and trial. I don't know how deep it is in the Odisha, but in the states like Bihar, this is very deep rooted. A huge number of offenders accused keep their arrest, keep evading their arrest and evading their trial. So there it can be very useful. This will curb this tendency to keep oneself absconding, because though they may manage those witnesses, they get them hostile and any other things in due course of time, because system gets tired and those witnesses and witness party and victim may also get tired and under pressure, fear or favor or whatever way they may win over them, or they compel them to sit at home and get hostile. But these provisions are document based. On learned court has got those documents where this proclamation was there, and that was executed by those police officials. Their report is there, and then this fresh case is there. So this is very difficult to get away with this particular provision. So you may kindly like to utilize these provisions more in future. So community service, only this provision 209 BNS is only cognizable offense, which is there in the community service punishment category. Otherwise, all other are non-cognizable. And standalone punishment is only regarding one offense there under community service. That is 303 subsection 2, where for first time offender where value of property is less than 5,000 rupees, upon return of the value of property or restoration of the stolen property, shall be punished with community service. So this is the only offense where community service is provided as a standalone punishment. Otherwise, in other 5 instances, this is one of those punishments. So this is one of those alternate punishments. But here, in this case, this is standalone punishment. And we have already discussed that this has been defined under, explained under section BNSS 23, the section which deals with sentences which magistrates may pass. Here, under explanation, community service shall mean the work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. So, to refresh our memory and to get clear concept about new offenses at a single place. Let us discuss this slide. So we have discussed most of them already, but at a single slide, 1 or 2 slides, we may discuss them again. Section 69, we have discussed sexual intercourse by employing deceitful means, etc. This is new offense added. Section 95, hiring, employing, or engaging a child to commit an offense. This is new addition. Section 103, subsection 2, murder by group of 5 or more persons acting in concert commit murder on the ground of race, caste or community, sex, place of birth, language, personal belief, or other similar ground. So this corresponds to, in common parlance, mob lynching. We have also discussed section 1061 corresponding to 304 Indian Penal Code, and this later clause is a new addition. In a single sentence, this new offenses has been added. In that, we also read that out. This relates to registered medical practitioners, and punishment here is lesser than other section simpliciter. So punishment here is up to 2 years of imprisonment and fine, whereas under subsection 1, this is up to 5 years. Former part of that. So 1062, we have discussed that this has been kept on hold, and this is a hit and run thing, and due to those discussed thought process, this has been kept on hold for timing. Section 111, organized crime, we have discussed it also. Section 112, petty organized crime, we have discussed it also. Section 113, terrorist act, we have discussed it, and we have discussed that the corresponding provisions of UAPA Act 1967. Next newly added offense is subsection 3 of 171, voluntarily causing grievous hurt resulting in permanent disability or in persistent vegetative state. We have discussed. Very strict punishment has been provided, 10 years to life imprisonment. Next, subsection 4 corresponds to those grounds as are there in the mob lynching cases. So there, grievous hurt, if one victim sustained grievous hurt. So this provision is there. Eleventh, I'm unable to see this. That 11th is not visible here. That is section 152, 152. That is regarding sovereignty, security, unity, integrity of India. That is because being added because that 124A existing provision, IPC, has been excluded to compensate that, to tackle those concerns, to tackle those challenges. That section has been newly added. And clause D of section 197 subsection 1, this also we have discussed, publishing false or misleading information, jeopardizing the sovereignty, unity and integrity or security of India. Then next newly added section is section 226. Attempt to commit suicide to compel or restrain exercise of lawful power. So this is an important addition. This is not there in the IPC. This has been added to tackle certain situations when certain person tries to commit suicide, to compel those authorities that these demands have not been granted, so I have to commit this suicide. So to try to blackmail those authorities. So lawmakers have found it necessary to stop, to curb such tendency. That's why they have provided this section 226. Though in general, offense to commit suicide has been excluded That we'll see in the slide dealing with exclusions. But here, this particular attempt to commit suicide to compel or restrain exercise of lawful power, this is added here as a new offense. And of course, this has been made non-cognizable. This is not a cognizable offense. This is a cognizable, non-cognizable offense. Then section 304, snatching, has been newly added. And we may be aware that there are certain states who, through their respective amendments, have already added section 379A, and in case of Haryana, most likely, they have added 379A and 379B also. So these were being added. But interestingly, this section 304 snatching punishment scheme here, punishment provision here is a bit disappointing. Why? Here, the maximum punishment is exactly similar to that which is in case of regular theft. Section 303 here, BNS, deals with regular theft, punishment and definition. So there up to 3 years imprisonment and fine. That is the maximum punishment provided under section 303 regular theft, and same maximum punishment is provided for 304 snatching, which is definitely an aggravated offense. There is hardly a very thin line between this robbery and snatching. So they have disappointed on this punishment part, ignoring that fact that already Punjab, Haryana and Gujarat, through those respective amendments which I mentioned, they have provided very strict punishment, very harsher punishments like 10 years or more imprisonment. Or in the 379B Punjab, Haryana, they have even 14 years in certain instances where they have prepared to, they have snatched with those preparation to use force and those weapon, etc. So here this punishment is very like regular theft only. And when we consider this fact that in the next subsequent section, that is 305, there are certain subsections have been newly added, which provides a special category of certain theft like vehicle theft and articles put in the vehicle. These have got higher punishment, up to 7 years of imprisonment. But this snatching, these poor victims of snatching, mostly women, elderly people, children, etc., and most of the time in the broad daylight, which sends a very negative impact regarding law and order also, public peace also. But this is with yeah. So in near future, we may see that our honorable parliament and may amend sooner than later regarding this. We may in the coming year we may see this development further. So next new provisions being added, offenses, I mean, that is section 305B, theft of any means of transport used for transport of goods or passengers, that is vehicle theft. Next, seize article or goods from any vehicle. Those words mean vehicle only. Like they steal not that car itself, but those articles, laptop or valuables or something put in the car by breaking open those windows or whatever, doors. So these offenses. D, theft of idol or icon in any place of worship. E, theft of any property of the government or of a local authority. So these are newly added crimes under this theft only, and this is a special category. So 7 years, up to 7 years punishment is provided here. Section 341, subsection 3, possession of counterfeit, seal, plate or other instrument knowing the same to be counterfeit. And 341, Subsection 4, fraudulent or dishonest using a genuine any seal, plate or other instrument. So these are 20 new offenses being added in the BNS, which are not there in the IPC. So now we may discuss excluded sections. IPC sections which are not going to find any place in any form whatsoever in the Sanhita, Nyaya Sanhita. So this is section 14, servant of government definition section. So this was found to be redundant. There was no need felt to define it further. So India in all three new acts, this definition of India is being dropped. This is very obvious. इंडिया क्या है ये स्वयं सिद्ध है, तो इसकी परिभाषा देने की जरूरत नहीं समझी गई है. Section 50 of Indian Penal Code defines even section itself. Section क्या है ये section 50 में जाके हमें बता दिया जाता है. So section 50 tells us IPC that what this section is. So this is quite obvious thing what section is under the Act's laws. So law makers found it redundant. Did not include, do not include. So section 53A, construction of reference to transportation, is also excluded. This penal provision, this section 124A, sedition, offense of sedition, Rajdroh is excluded. Rajdroh, there are specific terms which use those phrases like contempt and hatred against the government, etc. So now, as we have discussed, that section 152 BNS deals with this concern related to sovereignty, integrity, unity of our nation. So there is no mention of government as such. So we now talk about our law, new provision talk about nation India, not particular government per se. So from Rajdroh, those this colonial concept, although they also, Britishers also in the initial original code, Indian Penal Code 1860, they didn't have this provision. They inserted it later, some decades later. They inserted this provision 124A sedition to curb our these freedom struggle movement and tendency to resist against their colonizers' atrocities. They inserted this provision. Next provision which is being excluded offense is 153 AA, 153 AA. So this is punishment for knowingly carrying arms in any procession or organizing, holding or taking part in any mass drill or mass training with arms. So this has got interesting history. This was also inserted by that very important Amendment Act I have mentioned more than once during these discussions, that is Act 25 of year 2005. So this was added, and corresponding provision in the Criminal Procedure Code was also inserted. That is section 144A CRPC. So interesting part is that the legislature inserted these provisions, but delegated the power, as is often generally is the case, delegated power to notify the date of commencement, to appoint the date of commencement. That power delegated to the central government. So legislature did its part, but executive, central government failed to publish any notification, take any decision or notification. They kept it in bay. So these provisions were never notified, never. Though other provisions, those important, as we have discussed, like 174A IPC and 229A IPC, they notified to be in force from 23rd of June 2006. But they neither that particular government of the day which enacted these laws, nor those subsequent governments never tried to notify this. And now this, without seeing the light of the day, these provisions are going. So, and at the face of it, this provision doesn't sound to be useless. No, our nation is huge. So many things are there. Very complex society. So many outfits are there. So maybe some organizations, some outfits may try to do certain act which is defined and penalized under these provisions. And this issue was discussed in that honorable committee also. I have mentioned Parliamentary Department related honorable committee, which submitted its report on 10th November. After due to that first drafts were withdrawn and new drafts were introduced and that got enacted. So that committee also discussed this issue, and the government replied that okay, committee wrote. I perused that whole report of that committee, honorable committee. So committee noted this and requested the government that okay, this is important provision, so this should not be excluded. Then government reported that this was never notified. So strangely, committee put the end to this discussion, to this reply only, and then they finally did not recommend this, that this should be kept. And even had they recommended, even then some recommendation government obliged to honor and some not, like 377. So this is interesting history a bit of legal history about this section. So I shared it with you. Then section 236, excluded, that is related to coin and currencies. That is next section. These 4 sections, as we have discussed earlier, there's 4 sections related to weights and measures. So those sections have been excluded as that Legal Metrology Act 2009 was already enacted. Next section is 309 IPC, attempt to commit suicide. So there was a huge legal battle regarding Vairy's constitutionality of this law from 80s, various case laws, Honorable Apex Court, their verdict was that this is a violation of right to life, this particular provision. So it should be read down. But in the year 1996, in the case law Gyankor versus Union of India, Honorable Apex Court, this Constitution Bench of Honorable Apex Court, 5 judges Constitution Bench, decided its vires in favor of this law. They said that right to die cannot be treated as an integral part of fundamental right, that is right to life. Right to life is a separate thing. Right to die is a separate thing. So we cannot mix it. So this 309 IPC is very much constitutional. So this was Gyankor versus Union of India, 1996 Apex Court Constitution Bench judgment. But later on in the year 2017, when this enactment was there, Mental Health Care Act 2017, there under section 115 subsection 1, this is stipulated that notwithstanding anything contained in section 309 of Indian Penal Code 45 of 1860, any person who attempts to commit suicide shall be presumed, unless proved otherwise, to have severe stress and shall not be tried and punished under the said code. So, in the favor of such a person who tried to commit suicide, in the favor of this strong presumption has been stipulated. presumption is that it shall be presumed unless proved otherwise. So burden onus is on prosecution side, that if we want to prosecute such person, then we have to prove first that this doesn't fall under this is otherwise case. To have severe, otherwise this will be presumed that that person was having severe stress, and of course due to this provision that person needs medical care, not a prosecution, not a trial, rather medical care. So due to this provision, this scope of this section was already hugely minimized. So now lawmakers have found it unnecessary to be kept in the Sanhita. Section 310 thug, definition is there, thug, and section 311 punishment for being a thug. So we are aware that in the times of East India Company only, this used to be a huge menace. Those traveling caravans, whole group, even many a dozen of inmates were perished within a flicker of this thing. That was such a bloody organization of crime, that thuggy, that they were very organized system, and they were having their own code language, and with that they will command in a instance, जिसको हिंदी में कहते हैं पलक झपकते ही, whole group was finished. They were already there, graves were dug already by certain specialized, they are members of group, then they, so this was huge. If one is interested to know about this very black chapter of history of our this, then one may read this Confessions of a Thug. This is available freely on the internet, Confessions of a Thug. So Sleeman, Colonel Sleeman's team was, credit goes to that Colonel Sleeman, who was after these thugs all over India, chased through, and mostly this was wiped out, this menace. So, but this penal provision was there, but this was not this particular modus operandi, this particular style of crime is no more exists. So that's why this is found to be necessary to be excluded. So they have excluded 310 and 311. 376 DA, I have kept this in this list of excluded offenses, because as I have discussed earlier, that this is intermediary category between that top capital punishment, which was given under the age of 12 year of age in the 376 DB. Now that has been extended to under 18 years of age. So this intermediary category of below 16 years of age is automatically gets redundant. So this is excluded. Now below 18 years of age, gang rape, that is punishable by death penalty. So this intermediary category is not there. Next is section 377, unnatural offense. So this exclusion even goes beyond Navtej Singh Johar versus Union of India, 2018 verdict. As I have discussed already, that verdict, Honorable Apex Court decriminalized only consensual part between adults, nothing less, nothing more. But now by this exclusion of this particular offense, we have left unprotected those persons, those victims who against their will have been victimized by certain that particular act by those perpetrators who are adult and who are not women. Women are covered under that definition of rape, adult woman, and boy child, that male child, is covered by POCSO. But adult male, adult transgender, or those innocent animals are left uncovered for time being. Maybe sooner than later, our honorable parliament get to do something about it. And this was interestingly, even after that honorable committee mentioned this fact particularly and recommended to include this. But somehow, this second draft, which got enacted finally in form of our present acts, couldn't incorporate it. So, next is lurking house trespass by night and house breaking by night. Definition sections, but there are already other definitions which define lurking, house trespass, and house breaking. So when house breaking or house trespass has been defined properly, appropriately, adequately, then this is hardly a deal that by night. So this is quite obvious. So this was found to be redundant, and these definitions and these sections have been excluded. Then this is not visible here somehow. Then section 397. 397, adultery. As we are aware that by Honorable Apex Court, under this judgment, this Joseph Sign versus Union of India. कुछ गड़बड़ी होगी, नहीं दिख रहा है, sorry. So that was also read down by Honorable Apex Court. So that is finally, that is not here, that is excluded. And that's why that number of compoundable offenses has reduced by 1 from 43 to 48, as I discussed earlier in the morning session. Now let us discuss for this, get a historical perspective and this, that previously repealed IPC sections. As I discussed that 500 plus 64 minus 21. 21 sections were already repealed. They don't exist. So these were, these are those sections. We can see there that section 13, definition of queen, was already repealed. Definition of British India, definition of government of India, they were already repealed. Some of these were repealed by Britishers themselves by in the 1937, etc. And some of these provisions were repealed by Britishers only, like section 62 also. This was repealed in 1921 itself. Then next 1934, 138A section. And some other sections when our this Prevention of Corruption Act 1988 was enacted, then corruption related offenses provided in the IPC were repealed. So some other these sections were, so this is the list of those previously repealed sections. So we are here now at this stage. Any questions? No, by not Healthcare Act 2017, that was not deleted. Only scope of that act was minimized by that strong presumption that this will be presumed unless contrary is proved that that person is having severe stress.
Specific section 309 is still there in BNS.
No, BNS, this is excluded.
Excluded.
Yes.
But there is section 226 is in BNS.
Yes.
Which is resembles with that. Only addition is to influence the government authorities.
Context is absolutely different. That gentleman is trying to compel or restrain some lawful authority by restrain or compel to exercise certain lawful authority. So this is there is a certain sense of different thing. They want to arm twist by emotional blackmailing by this attempt to commit suicide.
Object of Mental Health Care Act is the same for both the sections 309 and 226. Attempt to commit suicide in both the cases.
Yes.
Then object of Mental Health Care Act is
both for both the sections, 309 and 226 of BNS.
Yes, by that effect, that will be applicable. But here, this prosecution side will say that, okay, this gentleman was not having severe stress. This gentleman was exclusively trying to compel us or restrain us from this exercise. So by such tikadambaji, they will try to get out of that scope of mental health care. But fortunately, rightly so, they have kept it non-cognizable so that police straight away don't go to abuse it or misuse it. Maybe that's why they have deliberately kept it non-cognizable. Otherwise, they could have made it cognizable also. They are adding it. And otherwise also this may be some sort of dichotomy that at one hand we are excluding one existing
Seizure.
provision completely, and at the other hand this is there. So that's why from civil society, some human right organizations related to human right or some civil liberty activism, they are saying, what is this? I am going to sit on hunger strike for to request and make it a point to this. They will say in their language that this deaf system. So we are protesting against this system by hunger strike. Then you will tell me that you are trying to commit suicide. So you will
Liable under
punish
section
me or prosecute me.
26.
So these are the views. But of course, this law is ever evolving process, and two different, maybe conflicting interests, two sort of interests are in general in law, that a larger interest of society's interest at large, and some individual liberty interests, that particular accused interest, human rights, individual liberty, etc. So these lawmakers have this great challenge always when they are drafting something. Then they have to strike a balance between two. So these views will be there, and I'm sure that once this prosecution report files before any of our learned respected officer present here, this is non-cognizable offense. So this will come to you first. Then you will take that decision, and after that, some one party, aggrieved party, may escalate that matter to higher courts and constitutional courts. Then at the later stage, someday, we'll have certain guidelines by honorable constitutional courts also. Yes.
Thank you.
Thank you.
Sir, whether 279, 337 and 338 IPC is incorporated in BNSS or not?
Pardon?
Whether 279 of IPC, 337 and 338 IPC.
Yes, they are there. I'm not. Have you got any book before you, furnished by the academy, with you?
No, sir, we have not gone through till
Some
now.
some books of these have been furnished to you. Oh. 279, no?
Sir,
You mentioned 279.
sir,
So section 279 of IPC is here in form of section 281 BNS. And let me tell you if there is any change or it is completely there without any change at all. Let me read it out for you. Yes, section 281, 100% reproduction of section 279 IPC. Whoever drives any vehicle or rides on any public way in a manner so rash or negligent as to endanger human life or to be likely to cause hurt or injury to any other person shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. Not a single change. No punishment enhancement, nothing. Though under section 304A, where death is caused, that punishment has been enhanced, as we have discussed, under provided under section 106 subsection 1, that provision, 304A corresponding provision. But here under section 281 corresponding 279, there is no change at all.
Good afternoon, sir. We had a good conversation about this mob lynching part. Then I wondered that given the current circumstances where religious intolerance is rising and all, what might be the intent of legislature to give a bit of protection to such mob lynching crowd? Because if we see, the mob lynchers are actually getting some sort of a protection, isn't it? Because death is not a prescribed penalty for mob lynching, which is there for 103A, like first part. Death is there as a punishment, isn't it? Am I audible, sir?
I can hear you, but I couldn't get you on this point, that protection of mob lynch. What exactly do you mean by this?
So as you were telling, upon the recommendation of the committee, that 7 years punishment was removed from 103 part 2, mob lynching part. But if we see the maximum punishment which can be imposed upon such murders, 103 part 1, normal murder, death can be imposed. 103 part 2, I don't think death can be imposed in that part.
103, 2.
Yes, the mob lynching part.
How can we like this? Maybe
Or if I may, like,
I was wrong in my impression or something. 103, 2. Yes, I was not wrong. When a group of 5 or more persons acting in concert commits murder on the ground of race, caste or community, sex, place of birth, language, personal belief or any other similar ground, each member of such group shall be punished with death or with imprisonment for life,
then what is the
and
point?
shall also be liable to fine.
Then what is the point of having 103 part 2 as a separate thing? If the same punishment is the same,
Yes, punishment is the
we
same.
already have this unlawful, this common intention, common object thing is also retained in BNS. Common object, I believe, is in section 188 of BNS.
Yes, yes.
Then what is the point of having 1032? If the punishment is identical, then why is this 2 retained in the BNS?
This may be due to this certain this thought process is there, that by this separate provision, separately defining these things on these grounds, so certain motive, separate motive under other provisions may not be required, and other provisions, if they are easier on the side of prosecution, then that will still be available to us when we are going to prosecute someone under this provision. So because there was a huge hue and cry because of such incident was on rise, so there was a strong need to do on their part, law framers. That's why this is separately enacted.
No, sir, I'll just give you an example. Let us suppose in an area there is a communal fair-up is there. It's evening 8 o'clock. 2 drunk persons of Hindu community are going. They spot someone of the Muslim community coming from the other side. They pass some racist comments, let's say. The other person reciprocates. He just answers, why you telling like that? Then they get into a brawl. At that time, 2 other persons of Hindu community are coming. These 2 first persons, they tell that, see, this Muslim person, he is troubling us. Let us teach him a lesson. All 4 of them beat him up, bash him up, he dies. So that will be a case of murder. 4 persons are here. In another case, same situation, Hindu-Muslim flare-up is there. This Hindu leader, what he says, this Muslim leader, every day at 8 o'clock, he closes his shop, walks through this street to his house. So what he does is, he gets 10 of his goons, he attacks that person, kills that person. So here, this 103 part 2 will be applicable for the second fellow, who came with more than 5 people. But for the first people, 4 people, the 4 accused were there, second 103 part 2 will not be applicable. So how is this answering the issue?
So this is how they have made it. Otherwise, where this is not that particular incident does not cover this element, the 5 or more person, then other provisions are there. Only with them we'll prosecute. Where this particular condition is fulfilled, we'll prosecute under this provision. So such threshold are there, like unlawful assembly related provisions also. When we start that assembly, before that also less number of persons execute that commit that crime also, those are not covered. So there are
That we can do in formal
certain,
protection.
yes.
So here I did not understand why is this 103 part 2 a separate thing from 103 part 1? If the punishment is the same, then only just for this.
They are specifically defining those circumstances on these those particular grounds. They are lawmakers are particularly sensitive to this newly emerged scenario that we are a very diversified society, and there are certain issues in the various parts of our nation. Certain issues, certain incidents came up, so they were worried, anxious, and they tried to address that. So a different category of crime. Someone may like to say that this is an aggravated category of murder, or someone may like to say this is a special category of murder, whatever that is. They have provided this thing with this particular thing in their mind. Of course, initially they had this third alternate provision also, as you have mentioned, that wherein that punishment is exactly similar at par with murder. So what was need after all? So, but initial that clause, there must be such thought process behind that alternate punishment up to 7 years, not less than 7 years they were providing. But later on, after those deliberations, discussions in the honorable committee, parliamentary department related committee, standing committee, they finally got to this recommendation that, okay, this should be at par with this, so that any discretion is not left to those learned trial judges. They should deal it with like regular murder, only with these additional circumstances, additional ground, additional motive, etc.
Publish.
Thank you.
With this, we come to the end of the third session, and we'll be assembled here after 15 minutes for fourth session. Thank you. Welcome to the today's last session. That is session 4. The deliberation will be on Bharatiya Nagarik Suraksha Sanhita 2023, overview and comparisons. And our research person is Sri Rajasekhara, and IPS Director, CDTI Hyderabad. Now, I request sir to carry forward the last session of today. Thank you.
Thank you. Good afternoon or good evening. Sir, Director sir, and all the esteemed faculty here, and our senior sir and Kishore Yadav sir also, Director CAPT, and my esteemed colleague Shri Bhavalal Meena, Director CDTI Kolkata. So I will go through quickly the overall sessions. Of course, there are 3 sessions for me. Tomorrow also I have 2 sessions. I will cover the whole entire BNSS. What are the things that have been changed And also we discussed especially importance on some of the topics that has been there, 187, that is the investigation beyond 24 hours, and FIR, that is the preliminary inquiry that has been added, and the complaint to the magistrates, and the forfeiture of the property under 107 of the BNS. So we will give special emphasis to that one. Otherwise, what are the changes that has been made entirely in the Bharatiya Nagarik Suraksha Samhita? We will go that one. Yes, first the definitions, you can see some of the new definitions have been added in the Bharatiya Nagarik Suraksha Sanhita. One is the audio video electronic means. Section 530, that is the last but one section of the BNSS says about that everything can be done in the electronic means. You can give e-summons, you can conduct the e-proceedings, the videography, everything is there in the 530, section 530. That is the last but one section. There are 531 sections. Say audio video electronic means there is in 121A, bail bond, electronic communication. See, the bail and the bail bond again have been defined. Bail without surety, bail bond with surety. And electronic communication, so taking into consideration the technological aspects that has been included in the Bharatiya Nagarik Suraksha Sanhita. And also, bail have been defined, have been broadened by eliminating the requirement of the accused person being formally charged. Now, this is the very important thing. Now, the accused person need not to be formally charged for this purpose for the accused. Now, how it is this one? As the Home Minister was also telling, these are victim-centric laws, whereas earlier it was said that they are accused-centric laws. So that's why till the trial is over, now there are many occasions that the victim will not get whatever the compensation or whatever the claimants and all those things. Now, even during the investigation or even during the trial, he may not be formally charged, the accused, but it will help the claimants or the victim to get what their claimants or the compensation in this there. Of course, the one of the main addition in the Bharatiya Nagarik Suraksha Samhita is the witness protection scheme. Of course, the witness compensation scheme was there, but by adding that, the victim need not, the accused need not to be charged. Now the victim will have a larger scope to get the whatever the due he has to get from this one. So victim can participate in any stage of trial more than, so this is also one of the court judgment, that is the Jagdeep Singh versus the Ashish Mehra, this one. It earlier stated, this is not the new thing. See, some of the things that has been added in the all the three laws were the result of the court made laws. So one of the thing is that victim can participate in any stage of trial more in cases where 7 years or more is the punishment, where the offense is more than 7 years or more. There was a committee reforms, and thereafter on the recommendations of the committee, this section was also added that this one, that in this from out of this case. Then investigation, of course, investigation means collection of evidence, but that is there in this one. But anything, for example, in any other act, the investigation is defined otherwise, then the special laws obviously will take the precedence over the normal general laws. See, from the court point of view, now the court structure has been changed a little bit. Of course, there is an High Court, and below there is a Sessions Court. In the Sessions Court, Additional Sessions Court and the Assistant Session Court. But the Court of Assistant Court, Sessions Court has been taken away. Now, in the Sessions Court, of course, the District's Civil and Session Court, there was a little bit change in Odisha also. I was talking to Manasji yesterday. So, there are the different nomenclatures will be given in different states. So, Additional Sessions Court will be there, Additional Sessions Judge, but there will be no longer Assistant Session Judge. As far as the magistrate courts are concerned, of course, the Chief Judicial Magistrate is the boss. Below him is the Judicial Magistrate of the first class and Judicial Magistrate of the second class. So, but there is no, of course, in the overall country, not much existed on the Judicial Magistrate of the third class was not there. But on the other hand, in the metropolitan cities, you know that there is a Chief Metropolitan Magistrate and the Assistant Chief Metropolitan Magistrate. But these Assistant Chief Metropolitan Magistrate and the Chief Metropolitan Magistrate, so Chief Metropolitan Magistrate was on par with the Chief Judicial Magistrate, but these were not there. Now what is remaining then? High Court, And in the lower court, it is the sessions court, which consists of the additional sessions court also. And in the magistrate courts, CJM, and below him is the JMFC and the JMSC. So obviously the powers, you know, that the sessions court can give any sentence, including the death sentence, imprisonment for life for those. And the sentence has to be confirmed by the division bench of the High Court, that you all know. And if there is a difference of opinion between the two judges, then it will be either be forwarded to the higher bench, constitute a higher bench, or it will be given to the senior-most judge. That all you know. And whatever the penal provisions, now 5,000 to 10,000, that is the JMSC, whereas 10,000 to the 50,000 is the JMFC. That is the penal provisions. Above 50,000, you know, that is the Chief Judicial Magistrate. So this is the structure of the magisterial powers now. And under section 15 of the Bharatiya Nagarik Suraksha Sanhita, there is one thing called special executive magistrate, not below the rank of superintendent of police. See, these executive, they are on par with the executive magistrates. Now, the police officer is also given the rank of special executive magistrate. But however, in the Bharatiya Nagarik Suraksha Sanhita, what are the powers of the special executive magistrate is not there, but on par with the executive magistrate. What does it mean? If we go to the commissionerate system, if we have the DCP, Additional Commissioner of Police, Commissioner of Police, we'll have the powers under 107, 110, 112, 116, 117, 118. That especially at this, during election times, bound down and bound over this one. So usually in the rural districts, what the police will do, they will take up these cases and forward to the SDO or the DC office. Of course, the DC will nomenclate one of the subordinate officers to deal with these cases, especially in coordination with the SP office. But now with this special executive magistrate, not below the rank of superintendent of police, can deal this even in the rural district. Number one. Number two, the special executive magistrates, now why not below the rank of SP? Obviously, in the rural district, it is the SP, but sometimes it may happen in the range IG. Of course, in the sometimes in Odisha, maybe IG range is there rather than the DIG range. In certain states, it is the DIG range or the IG range. If the IG range or the state IG sits in that range, then obviously you will be the senior most officer in that particular district. So obviously you will become as the special executive magistrate. So the state government will nominate not below the rank of officer of the superintendent of police. Now section 3, constitution of references. This is very important, especially to understand the section of 187 and 173. If you go to the 187, that was the earlier 167 of the Bharatiya Nagarik Suraksha Sanhita, where the investigation cannot be completed within 24 hours. Then you have to forward it to the judicial custody. There, the question of 187, if you carefully see that the police custody is 15 days only, I will come to that later, but there is a word called, earlier in CRPC, there was a word called otherwise than in a police custody. This was specifically mentioned in section 167, now 187 of the BNSS. But now the words otherwise than in a police custody has been taken off. So that means to say that in CRPC, it was clearly stated that after 15 days, it is the judicial custody. But now, due to the absence of these words, the lawmakers are asking the question, and even in YouTube and everywhere it is asking the question, now the police custody can be more than 15 days. But if you see that one also, and in section 183, that is the earlier section 164 of the CRPC, that is the confession statement, there it is written, any magistrate of the district. Whereas in 164, it was judicial magistrate. So isn't it? JMFC was the one who was taking the the confession statement. But now, in the absence of the word judicial and putting the words any magistrate of the district, question arises whether the executive magistrate can also take the confession under section 183 when compared to the 184 of the CRPC. But if you see those words, the thing underlining is the construction of the references, that is the section 3, where it says that unless the context otherwise requires any reference in any law to the magistrate without any qualifying words. These are the words that we have to make sure that there any magistrate means it is judicial magistrate only. And otherwise than in the police custody, there also you should have to think that otherwise than in the custody means, as such custody means, there you have to see after 15 days, it is the judicial custody only. We will come to that later on, 187, 173 and thereafter 183. There you will understand all these things. Next, for executive magistrate, nothing in this section shall preclude the state government, commissioner of police for all or any of the powers of the executive magistrate. That is also there, 14.6. Then executive magistrate not below the rank of superintendent of police for particular areas of the performance of particular functions and confer such special executive magistrates. See, that is very clear. It is not that the whole district or something else. That means the IG is there or the DAG is there. He can be the special executive magistrate for the whole of the range or for the whole of the district as such a case may be. Next, central government to appoint public prosecutor or additional public prosecutor for the High Court of Delhi. You see, the Delhi has a different unique position. Delhi has its own legislative assembly, but it is not given to the state. Whereas Delhi police is under the central government. Now the question comes, who will appoint the public prosecutors to the Delhi High Court? Now they have cleared the area, doubt that the central government will appoint the public prosecutors for the Delhi High Court, and that too with the consent of the Delhi High Court. Next, 14 days notice to the state government before making such an appointment for a particular case. See, earlier what happens, since I am from the Nagaland cadre, I can appreciate that one better. See, in especially the rural areas, there are so many areas or so many districts where the APP or the PPP is not at all present. But the state government want to appoint them, but they did not go, or there are absenteeism or whatever it may be, the public prosecutors are not there. Then what usually as an alternative is done? Either the neighboring district court judge, public PP or APP, or the available APP or the PP in any of the other courts is asked to look after this one. But if the state government wants, then that was the case, but it was continuously been until such appointment is made. Now, if any important case come and the PP is not available, then what to do? The district magistrate can appoint any public prosecutor to run this case, and he has to give a 14 days notice to the state government. Next, 20 BNSS established a Directorate of Prosecution. See, the Directorate of Prosecution is the one which has been looked down actually, if you see. Investigation plus prosecution. Obviously, the result of the investigation can be better explained or viewed by the whatever the conviction rate that has been gone. But the Director of Prosecution is not at all uniform in all over the country. But it is very uniform in the organizations like CBI or the NIA. In CBI, I worked earlier in CBI, myself has seen there is a Directorate of Prosecution who sits in the headquarters. There is a deputy legal advisor, there is an assistant legal advisor, there is a senior PP, assistant PP, like this. There is a proper clear nomenclature of the Directorate of Prosecution. But it is not so uniform across all states. For example, even in Madhya Pradesh itself, a senior IPS officer of 1989 batch is heading the Directorate of Prosecution. If you go to Andhra and Telangana, it is the advocate who is heading the Directorate of Prosecution. If you go to Uttarakhand, there is the ADG rank officer who is looking after the prosecution thing. So that's why the wing of prosecution wing is not has been streamlined. Now it says that there should be a Directorate of Prosecution. Below him, there should be a Deputy Directorate of Prosecution. And one more, in section 19 of the Bharatiya Nagarik Suraksha Sanhita, they created one more post called Assistant Directorate of Prosecution. So this is the new post created by the in this law. So what are the eligibility conditions? As I told, it was not so uniform, and the government would have been, the Home Department would have been appointed whatever the officer it may be. But now it says that for the Directorate of Prosecution and the Deputy Directorate of Prosecution, an officer who has worked as a session judge or 15 years as an advocate can only be considered for the post of Directorate of Prosecution or the Deputy Directorate of Prosecution. Whereas for the Assistant Directorate of Prosecution, he or she might have worked as the JMFC or 7 years as advocate. So now it is more streamlined. Now nobody, IPS officer, nobody can enter in these. Then whatever their functions, the Directorate of Prosecution can monitor the cases and give the opinion on the file on the cases where the punishment is punishable with more than 10 years of 10 years. In those cases, if the state government refers those cases, then the DOP, that is Directorate of Prosecution, can give his opinion as well as on monitor those cases. Whereas Deputy Director, 7 years to 10 years of cases, he can monitor such cases. Less than 7 years, then it is the Assistant Directorate of Prosecution. So now the eligibility condition as well as their functions, duties have been streamlined very well in this. is a new law about the Directorate of Prosecution. So these are all the things that I already told about this one. That was earlier, section 25 of the earlier CRPC says that, yes, with legal experience of not less than 10 years was there, and that too with the consultants of the Chief Justice of the State High Court, the DOP would have been appointed. But now that has been taken off. Now, as I told, it is only 15 years. That is the same condition. The interesting is that eligibility condition for the DOP as well as for the Deputy Director of Prosecution is the same, 15 years as a advocate or worked as a session judge. So this is the whatever there in the law. That means the Directorate of Prosecution will be under the command and control of the Home Department, whereas Public Prosecutor, APP and Special PP are subordinate to the Deputy Director of Prosecution, and Assistant Director is subordinate to the Deputy Director of Prosecution. Next, these are the fines that I have already worked, but whatever the new thing, see, one of the important thing about Bharatiya Nyaya Sanhita is that one of the form of punishment, that is the community service. As sir was morning in mentioned, it was not given a statutory status. Earlier it was there. It is not as such that it was not at all there. But it was not defined in the Bharatiya Nyaya Sanhita, but it was given as an explanation in section 23 of the BNSS. It says court monitored work, beneficial to the community and without remuneration. These are the things that I have told about the community service. Then what are the offenses? They have identified 6 offenses where the community service can be given as one of the punishment. Mind you, it is not the exclusive punishment. The existing punishment is there. The enhancement punishment is there. But added to that one, community service will be one of the form of punishment in 6 punishments. So out of the 6 punishments, only in one case, only community service can be given as an exclusive form of punishment. That is the first time theft, less than 5,000 rupees, and the value of the good is returned. So this BNS has takes a reformative and a rehabilitative this one. Because of the overcrowd in the UTPs in the prisons, now they also taken the humanistic approach. For example, a person by mistake or by making opportunity or something, he has made theft of something. And it says the first time theft and the value of the good is less than 5,000. What is the condition? He has to give that property. It is not that I taken away something from the Orissa Judicial Academy, I pocketed myself, and the court has given half a day or 1 day community service of I work and I will be benefited. No. And it says even you return the good, but sometimes I chori kar liya, but have sell it to somebody, then or the value of the good, of course the wear and tear also comes into the picture now. So this one, then you can be given as the community service. Now again, it is not so clear who will implement what is community service means, but it only says that beneficial to the community. So what are the other 5 offenses? Of course, the public servant involving in illegal trade. We all are all public servants. When we are entering in the service, then we will give an undertaking that I will not enter into an illegal trade, isn't it? So in that way, whether the stock market and the crypto and all those things comes into the picture. Even in crypto, in stock market, they made this one. You can do a long-term investment, but not on a day-to-day trading. And also drunken person in public, creating a nuisance, isn't it? That is also eligible for community service. Not only in public, but I drunk, I gone to a public place, I illegally trespass one of the person, 447. Now, and I created a nuisance against person, again community service. Defamation, obviously you law students and you judges, you will be know defamation has 2 parts. One is it is a torture. It comes under torts also, and another one is the criminal. This one, as far as criminal, this one is concerned, again the community service has been given. As sir has pointed out earlier, the question was rising about the dhamki de rahe public servant ko that मैं आत्महत्या करूंगा, मेरे को ये कर दो एक. That means you are blackmailing the public servant to do an act which is not to be done by him or to prevent an act by done. So I will give some examples. Some of the communities or some of the persons will come to the DC office and say that when the DC is speaking or going to this one, आप ये नहीं काम कर रहा है तो मैं क्या करूं, मैं टावर चढ़ जाऊं और आत्महत्या करूं, आप TV tower या कुछ tree में चढ़ के, then they will threaten to blackmail. Even some months back, our Prime Minister was addressing a rally in Hyderabad, and one girl has climbed the tower, and Prime Minister was, बेटी मैं आपका बात सुनाऊंगा, आ जाओ नीचे आ जाओ, but वो लड़के बात सुनने का मन में नहीं थे. Now the question comes, what happens if in घर के अंदर में बेटी बोल देगा आप बिना स्कूटी नहीं देगा तो मैं स्कूल में जाएंगे नहीं और मैं आत्महत्या करूंगा. See, now that has been told that now the lawmakers have taken a good sense. Already the person who is giving threatening for the blackmailing, this one already in such some sort of a distress. So if you make it more criminalized, then it is not so good. So the law says that in such cases where the blackmailing of the abet to commit to suicide is there, but it is not criminal, not to prevent of some legal officer or some public servant. In those cases, you treat that patient in the Mental Health Care Act 2016. That means to say that you treat him by counseling or he or she has counseling and all those things. But on the other hand, if you are making a public servant to do an illegal act, then it is a criminal act. And what is the punishment? The punishment is that is the community service. So these are the things. And another punishment is section 84(4). That is the proclamation offender. You issued a proclamation notice. Obviously, I will come to that one, section 84(4). Now the proclaimed offender has been also increased ambit. Now earlier it was not so clear. In section 84(4), any punishment more than 10 years of offensement, then you can declare that offender as a proclaimed offender. Number one. Number two, the proclaimed offender not responded to the proclamation notice issued. Then what should be the punishment? The community service is the punishment. So these are the 6 punishments that are being involved for the community service. Earlier, there were only 5 parts of punishment. Obviously, you know, that is the death penalty, imprisonment for life, imprisonment either rigorous or simple, then forfeiture of property, and the 5th one was the fine. These were there, but the 6th one is the community service has come as a very statutory or a legal form of community as a thing. Now the question is, what happens if the person do not act according to the orders of the court to sweep or whatever the work given for as a community service? Now, in default of community service not done by the accused, now imprisonment can be given by the magistrates. Further, community service can be given by only by JMFC as well as JMSC. So these are the additional powers that has been given to the magistrates. So matter of sentences in several offences. You see, you being the magistrates, we need not to tell the judges. Earlier, the default rule was there, isn't it? That means the sentences run concurrently. If there are 2 or more sentences there, then if your magistrate or the judge does not write in the order that whether the sentences run concurrently or consecutively, then it assumed that the sentences run consecutively. But now it is sure that the magistrates or the judges in multiple offences has to specifically write in the order that whether the sentences run concurrently or consecutively. Okay. Next, Court of Magistrate might award such term of imprisonment in defaultment of payment of fine. I will not go to this one, that you all know. One for now, in default of fine or in default of community service, what can be the imprisonment? Obviously, 1/4 of the maximum punishment that is there, and all these things you know. That no arrest, this has already been discussed, may made in case of offense punishable less than 3 years if the person is infirm. Infirm means mentally and physically not so sound, and above the age of 60 years. If the accused is mentally and physically not so good and above the age of 60 years, then you require the permission of not below the rank of the DSP of that district, and the infirm male below 15 years. Further provision is that you cannot call these category of persons as a witness to the police station also. Who are those? Male below 15 years, women, physically and mentally disabled person, or above 60 years of age, and acute illness. See, this is the word added in acute illness newly in Bharatiya Sanhita. See, if you see the IPC, there are some colonial words: insane, idiot, lucene, isn't it? But these words are taken off from the IPC. Now, a more Sanman Janak, very respectable word of what? Acute illness, that has been started in the Bharatiya Sanhita in those words. So these category of persons under section 179(1), there's a witness need not to attend the police station. They can attend from their home only. Obviously, the audio, video, electronic means is there. They can attend via videography. Next, Every district. See, if you see the DK Basu versus State of Bengal, and also the same was stated, some of the provisions stated in Jogendra Kumar versus State of UP, the rights of the accused, what are the provisions, how to arrest, make, and all those things. You have the 18 guidelines, and these guidelines are put in every police station as a placard, and also this. There was one provision that when you are making the arrest, please inform the grounds of arrest. Second thing, inform his relative, friend, or the responsible person of that locality. These words were there. And also, you should have to set up a police control room in each and every district, which disseminates the information about the arrest made. But sometimes when we go for territorial jurisdictions, that means beyond my police station or beyond my district, then it causes a somewhat who is his relative and all those things may not be properly disseminated. That's why now it is compulsion for each every police district as well as the police station to appoint an officer, police officer, that is assistant sub-inspector, especially for this one. Okay, whenever the arrest has been made, whether you are in the district or something else, when you go to the other districts and you make an arrest, you identify the police station, and from that police station, there is an assistant sub-inspector who should be specifically for this purpose, and you give the information to that assistant sub-inspector, who in fact is duty bound to inform the relative or the friend as the case may be. Next, 6 hours. See, earlier, as per law, there are 3 persons who can make arrest. Obviously, police, magistrates can also arrest, and the third is the responsible citizen, isn't it? But as a responsible citizen, sometimes it comes to some of the court cases are also there. I can arrest Bawarlal Meena, but I did not go against him. I am not in line with him. So as a citizen, I can arrest and put it in confinement and stating that the arrest time is 24 hours, excluding the time taken for journey, isn't it? There are chances like that one. But you may ask whether private person's arrest happens. I don't think it is too prevalent in Odisha. Is it too prevalent? But in Assam, it happens. In border areas, it happens. Since in our northeastern states, in Assam and when we border with Bangladesh, many people will smuggle cattle. Our public civilians. So public aake unko pakad ke police station ko dete hai. So there, it is not so uncommon. It is common there. Private arrest by a private person. In those cases, now the provision is there that 6 hours. But 6 hours from the legislator point of view, we can say excluding the time taken for journey. Now 2 questions, sir. Sir, already the private person has arrested a person and handed over it to the police officer. It says you have to hand it over to the police officer if not available to the nearest police station. Okay, that is already there in the CRPC, earlier CRPC also. Now 6 hours, whether it will add it to this police station the 24 hours gap, or the 24 hours starts immediately the private person handed over to him. The answer is that it is added. That means police officer will not given another 24 hours extra on and above the time taken for journey or the whatever this one. So whatever, for example, a private person take 4 hours, then you have only 18 hours. So that the illegal custody or the wrongful confinement is not there. Second important thing compared to CRPC is that in the CRPC, it was called rearrest. When a private person handed over that person to the police officer, it was rearrest. But now it says already the arrest has been made by the person, civilian or the private person. Now no arrest. It is just changing the custody or taking into custody. The word rearrest has been changed as taking into custody. Then third thing, what happens to the seizure memo or the whatever the arrest memo and all those things? Obviously, the private person will not prepare it. You can take him as a witness or whatever it may be, and you have to prepare. Obviously, these procedural things had to be done by the police itself. So these are the things that the people are usually asked in this one. Even in Assam Judicial Academy, where I was taking the sessions, many of these questions came. Handcuff. See, earlier in CRPC, there was no particular thing in what cases the handcuff can be used by the police. The courts are very stringent, especially on this one, because taking into the concept of Article 19(1)(a), 2021, that is the right to freedom of speech and liberty and right to life. So the accused is accused only, and in all the cases, you cannot handcuff. If you remember, in Delhi, when even in the Parliament attack case, some of the advocates gone to the court and said that let the police take the permission even to handcuff those accused, isn't it? So because the fundamental rights, the 19, all those important. Now in handcuff, who can get handcuffed is clearly defined in two cases where he has either escaped from the custody or an habitual offender. Section obviously 110, or either he has escaped from the custody. And in what cases? These are the cases. So heinous offenses like organized crime. As already discussed, organized crime is a new section, new crime under Bharatiya Nyaya Sanhita, that is there under 111. Organized crime. But the lawmakers come to know that organized crime is a huge gambit. But there are some petty offenses like ATM theft, selling of tickets, railway tickets, movie tickets, T20 World Cup tickets, selling of the question papers, ATM theft, and pickpocketing theft teams are also there. So they again made another section under 112, that is the petty organized crime. Obviously 113 is the terrorist act. So organized crime, that is 111 and 112. Then terrorist act 113. Obviously it is the carbon copy of which act? UAPA section 15. It is almost the same copy of the section 15 of this one, that is this one. And drug related crime, that is the NDPS cases. Then illegal possession of arms and ammunition, that is the Arms Act, usually invoke section 25 and section along with section 84. That is very more prevalent in the underground areas, like in our state. Murder 103, rape. Somebody was asking for the previous sir that sir, murder 103. Why mob lynching and all those things? If you see the wordings of that there, the murder happened because of the social profile of the victim, isn't it? In those areas, community, caste, place of birth, belief, in those areas, in those aspects, 5 or more persons they are involved in this one. So maybe why 5, why not 4? We cannot give that one. But if there are 2 persons, 3 persons, or 1 person, there are more chances that the person who is a victim can give somewhat a fight, or he has a chance to escape. But especially this mob lynching was added to prevent the hatred between the communities. I'm from the Northeast worked. I can see that you can remember some decades back, some of the people from Northeast, Manipur, Nagaland were mob lynched in Delhi. You remember those cases in Bangalore and all those things. So to prevent this one and to promote communal harmony, this one, that why the mob lynching under 103 has come. Obviously, section 117 of 4 is mob lynching again, the same parameters, but the person did not try, but he get voluntarily grievous hurt. So there the difference of punishment is there. Again, voluntarily causing grievous hurt, earlier section 323, now it has been redefined, stating that the person having the painful injury for how many days? 15 days. In the earlier IPC, voluntarily causing grievous hurt, that was stated that the injury, that pain lost for 20 days. But due to medical advancements, now it has been 15 days. So murder 103(2), where mob lynching result into murder, death penalty is there. Whereas in 117, the same mob lynching, but resulted in grievous hurt. Grievous hurt means now it is 15 days compared to that is the 20 days earlier. Okay. Then terrorist act, drug related arms, ammunition, murder, rape, of course, section 63. Punishment for rape, but obviously we have a different section, that is section 70 in the Bharatiya Nyaya Sanhita for gang rape. You know that gang rape, again 2 things, minor, below 18 years of age. Now no category of 12 years, 14 years, why this, that is not there. The gang rape of only 2 categories. Gang rape of a minor girl below 18 years of age, where death penalty, whereas above 18 years of age, now minimum 20 years punishment is there. So rape. Then sexual offenses against children. Yes, importation of the importation was there. Section some section was there. That is the offense against the children. Acid attack, counterfeiting of coins and currency notes, and human trafficking. Of course, it is a schedule under the NIA also. It is very interesting to know that anti-human trafficking cases are also taken by the National Investigation Agency, where they thought that they used the terrorized means, not necessarily terrorist, but the means they used are terrorism kind of a means. That's why Anti-human trafficking is also one of the scheduled offense under the NIA Act. And the last is offenses against the state. Very important. Offenses against the state is under section 152 of the Bharatiya Nyaya Sanhita. That replaced, or we can say that has come in place of section 124A. That has been repealed. That is the earlier treason or sedition. Isn't it? That's why in the papers or wherever you go, it was usually called the earlier Rajadroh was replaced by Deshadroh. The words Rajadroh, Deshadroh were never there, either in CRPC or in the BNS. Why it is so called? Because under section 124A of the IPC, it was against the government or against who is in power. That means Raja. That's why it is called as Rajadroh. There is no word called Rajadroh. But the lawmakers think that during independence times, we go against the British laws, Dandi March, Salt Satyagraha, against the British Raj, British made laws. But if we keep the same thing, then it violates Article 19(1)(a) of the Constitution. So let us put away that one. Anybody can say anything against the government or the person who is in government in power. Of course, we public servants cannot do that one. But what you cannot do is section 152. It says acts endangering sovereignty, integrity, and territorial integrity of the nation. These are the words there. So that is there under 152. That is now called as Rajadroh. So in those cases also now you can handcuff the person. So this is about the handcuffing. Next, women shall be arrested after sunset and sunrise. See, this is the thing. No women. Yes. Earlier, there was an offense called house break by theft by night. But night word has been taken off. Why? Why? Because in Northeast, the night time says this one. I think in Nagaland, by this time, it is already dark, 4 o'clock. And we have early sunshine, 3:30, 4 o'clock, we have a sunshine. So the night differs there because the time zone. So they carefully added the words like night means after sunset and before sunrise. So the woman cannot be arrested in night. So the words night has been taken off and these are the words added. Next, section 50, police officer or other person making arrest immediately after arrest is made, take offensive weapon which he has about his person and shall deliver all weapons and all those things. See, this is one peculiar provision, or what we say, somewhat what I consider is that about with the section 27 of the Evidence Act. But now earlier section 27 of the Evidence Act, now it is section 23 of the Bharatiya Sakshya Adhiniyam. That means confession made to a police officer is admissible provided the victim leads the way to the availability of material evidence. So what I presume we understand from this point of view is that murder happened, scene of crime is there, I arrested a person, there is a weapon there, but I do not take the weapon. What I do? Arrest after some time, let I take the accused, you find the way, and let I capture the weapon through accused so that I can take the provision of this section 27 of the Evidence Act. So prevent that one, this section 50 has been added. Now the medical practitioner shall without any delay. Now the medical practitioner, obviously CRPC nor the BNSS does not say about doctor. The word doctor is not there. It is called as registered medical practitioner who has registered in their own medical council or whatever it may be. Now, two things, medical practitioner, registered medical practitioner in medico-legal cases or whatever it may be. In any other case, shall without delay. The word shall has been added. That means it cannot cause unnecessary delay. But in rape victims cases, it has to be done within 7 days. So these are the words added there. Then if the medical examination has to be conducted and the doctor feels though additional medical examination, then if he feels though, then it is duty bound that the police has to cooperate and take additional medical examination as well. Next, summons. See, summons, the earlier thing is that adult male member of the family, isn't it? Adult above 18 years, male, family, you know the definition of the family, and it also specifically says in CRPC as well as BNSS, the servant of the house is not the family member. This is specifically mentioned. Now, what are the changes? Now, first things first, that male has been taken off. Adult member of the family, making it as gender neutral. Because, you know, in earlier CRPC, century old together, they take that some communities like in Rajasthan, Pardanishan women, Burqa women, and police has gone to the village and police aa gaya, sabhi log dekh rahe, it was seen as a very this one. On top of that one, police bulare koi mahila ko aur de rahe summons. Then it viewed as a very thing, and they think that let us keep away the women and only summons can be issued to the adult male member of the family. But now things have been changed. It says that adult member of the family. Number one. Number two. Now you can serve the summons electronically also. That means take the summons. There should be a proper seal and signature of the issuing court. Serve it. And two things, you maintain a register in the police station, name and address where it has served, and also a register in the court where the summons have been issued electronically. But what is the main thing? It has a proper BS seal and signature on that e-summons. Of course, due to fake summons, fake videos and all those things, there is a chance that somebody want to settle the scores. They can create a fake summons also. That is out of question. But now we have to see what is the genuineness of that electronic record or whatever the e-summons. Apart from those issues, now you can serve e-summons. Now, what is the use? See, this has a lot of issues, especially in the Northeast. In Northeast, what happens? I'm just giving our own example. Assam Rifles. Assam Rifles is there. They register a case under section 384, extortion case. They come up with arms and the major of Assam Rifles register the case with us. The trial comes after 10 years, 5 years, whatever it may be. By the time the whole company has moved out, the major obviously would have been transferred out. 9 out of the 10 cases, we are unable to get the major or whoever the complainant is there to come to the trial. So that is a big blow for the prosecution. This may happen in even in mainland also. But now what happens if you know his mobile number or some address, you send it to the headquarters. But earlier what happened, even if you sent it to the headquarters in Delhi, hardly it gets served. Of course, it has a 15 days timeline and we have to again issue the summons and hardly nobody is bothered about. But at least with this one, we have the office address that has been traced through the internet or the whatever it may be. Then you send it office wise and you know the when it is reached and whenever it is not reached as per the section various provisions of the Indian Contract Act, that when it reaches to the proper computer of that office, it appears to have reached. That sections where we will keep it otherwise, but these things will be taken care. That means you send the summons electronically, these whatever the summons have been there. So this will be going to be a very good thing for the issue of summons and their service. Okay. Gender neutrality is some adult member. Case of arrest, warrant section 82. Cast duty police officer, yes, this is on the territorial means. You are making an arrest apart from your territory, then you have to inform the ASI, assistant sub-inspector, as I told. Person could have been declared proclaimed offender under section 84(4), I already told. Now the proclaimed offender ambit has been changed. Any punishment more than 10 years, now that offender can be declared as proclaimed offender. To be precise, there are more than 100 offences in the Bharatiya Nyaya Sanhita now, which can attract 10 years of punishment due to the enhancement of the punishments. Then 86, identification and attachment of property. See, proclaimed offender, property of proclaimed offender. Superintendent of Police or CP, Commissioner of Police, initiate request assisting from the court authority in contracting state outside India, proclaimed offender. See, this is on reciprocal. I will explain. See, assisting state means the contracting state, assisting state means any foreign country where we have signed the MLAT, that is the Mutual Legal Assistance Treaty. Earlier in the CRPC, what happens is that, for example, if I want to conduct investigation abroad or identification of property, I take the permission of the court, forward it to the SP or with the permission of the CPRO, it will be forwarded to the Interpol, that is there in the 6th floor of the CBI. From there, it will go to the Minister of External Affairs. From there, go to Indian Embassy. From there, go to foreign embassy. From that, if he's staying in London, then it will go again the same process. Then it will go to the chief secretary, TGP, or whatever the setup there. Many years have been gone and the letterogatory or the MLAT or whatever the request, they are hardly been serviced because of the cumbersome process. Now, it has been streamlined for identification. Requesting assistance from the court authority, contracting state, identification, attachment, forfeiture of the property belonging a proclaimed as a reciprocal arrangement. Reciprocal arrangement means as far as MLAT. And mind you, the offense committed here should be the offense there also. Then only it is considered as a reciprocal arrangement. Next, 105, audio videography of the process of search and seizure. As a police officer, this is a major blow as far as the police officers is concerned. Why it is sin? Because of the allegations or the wrong procedure of search and seizure that we police officers conducted. First and first, when we go for the search and seizure, we do not offer body search. See, before entering the house, what the CRPC law says that first you offer body search by the inmates of the house. True or false? It should be there. Why? Why? Because it is easy to take some pen drive or some NDPS and put it in the accused or the victim, whatever their bed and say that, aha, I found these are the things which are very important. That's why the allegations come that police have planted the evidence, isn't it? So this we do not do. Second thing, what we do? We will not be there in the search and seizure for a long time. We take all the documents, whatever there, come to the police station, आराम से बैठ के क्या चाहिए क्या नहीं चाहिए उधर ही विटनेस को बुलाए उधर ही इनमेट ऑफ द हाउस को बुलाइए आराम से बना के we send on our own this one, isn't it? कई बार होता है, आपको सुना होगा, इसको कहते हैं पुलिस विटनेस. मैजिस्ट्रेट्स भी हैरान हो जाते हैं, यार यार ये केस में भी वही विटनेस है. वो भी विटनेस कौन है? हमारा पुलिस स्टेशन बगल वाला चाय बनाने वाला विटनेस है. True or false? So these are some of the procedural mistakes while doing search, seizure and this one. Now they made it, no, you compulsorily videography the search and seizure proceedings. And that videography should contain independent witness signature. Also that seizure report has to be prepared in this place where the search has been made. There made. And you take the signatures there only. Third important thing. When the searches are over, within 48 hours, excluding the time taken for journey, you send the search and seizure report to the jurisdictional magistrate. Now, under 165B, where there is no need of a search warrant, that means I take one search warrant. It happens in NIA and CBI cases when I am conducting multiple searches. Thereafter, I send my subordinates to the different places and they are conducting under section 165B. Now, all officers have to gather because we start the search simultaneously to maintain confidentiality, but different search places will take different own timings. NIA will take, sometimes we have to spend morning to evening and all those things. This is it. But now, when all officers have gathered after the search from different places, take the time, 48 hours. After that, you have to produce those search and seizure report to the court. Now, the big question comes, what about the videography? Okay, it says that preferably by videography. ठीक है, 1 घंटा 2 घंटा videography मैं mobile में कर देता हूँ. But the problem is that when I download from my mobile to that one, now the hash value, of course, the hash value doesn't come into the picture, especially mobile, it comes only in the laptops. Now, what is the true fact about that? Much more this one. Having said that videography should be a very compulsory for search and seizure, now it is a part of 173 CRPC or 193 police report. There are 10 accused. You make a 10 copies of the videography, give 10 copies of videography to the accused. Now the accused counsel or the accused will open and say, aha, ye police ne ye galat kiya, they will make shots, wheels and all those things. Now it will open a Pandora box. If you ask me, and they will find police ne ye nahi banaya, police ne aur kuch cheez kiya, magar videography nahi kiya. So again, the problems here is not going to end, but it will add more problems to the police officers. Added to that one, police station logistic. 1 घंटा 2 घंटा, take a pen drive and all those things. If it is going more than 10 hours, 12 hours, and had to take multiple searches, एक TV का hard disk लेके आ जाओ, then you take it that one, send to the forensic lab, make a cloning, again 10 multiple copies, give it to, then it will cost 30,000-40,000 and it is a huge burden for the police stations also. These are the things that is going to happen, especially when the search and seizure has been made, this one, and the lawyers will also make n number of mistakes. But this one is that, of course, on line, on the paper, it is to make more appropriate, apt to conduct the search and seizure properly by the police officers. Okay, that is there for the search and the seizure. And interestingly, forwarding recording to DM, SDM or JMFC, it is there. That means search and seizure can be forwarded to DM also, SDM also, or the concerned judicial magistrate of the first class. and logistical issues, secure digital evidence in PS, court, and all those things. See, in Bharatiya, Nyaya, Sanhita, and the audio video electronic means and document, section document includes electronic and digital records added with section 61 in the Bharatiya Sakshya Adhiniyam, which is newly added. Now, everything you are telling that videography career, technology career, and all those things. Now the question comes, where the court will keep all these electronic evidence? This was one of the question asked by the judges in Assam. Sir, आप ये बोल रहे ये भी videography आ गया, ये भी आ गया, ये pen drive आ गया. Court में we don't have the logistic this one. Then the best thing is that in many of the NDPS cases are when the vehicle has been seized, what the magistrates or the court will order, you keep it in the police station. It is as good as in the court jurisdiction. Now what the court will do is that let it be kept in FSL, kept all the electronic evidence under this one as if it is in the custody of the court. Now the FSL has to again improve their logistics to store all these electronic and digital records. This is what I presume. Next, 107, a new provision, court to attach forfeit any property obtained as proceeds of crime. This is for proceeds of crime. This is the new section, 107. First time such provision, crime has been introduced, will deter fugitive criminals and act as a compelling factor. We will come to that one, 107. Now, what is this one? 107, what is the procedure? Attachment, forfeiture, or restoration of property. Again, this is a huge question that has been, because this is a new provision. It says, even during the investigation, I want to take approval of the SP or the Commissioner of Police. That means there is a property attached in a particular case, and you know that property belongs to this and this person. And obviously, now it says in the definition clause only I told, victim, for the definition of victim, the accused need not to be formally charged. Now come to 107, adding with that one. Now the accused is not formally charged, but the victim want to take away or claim over property. Now what happens? IO investigating officer will take the permission of the SP superior officer. Application to court, jurisdictional court, he will apply this one. Next, magistrate who can take cognizance or committal or trial. I heard that there is a separate SDJM even for cognizance here in Odisha. So committal or trial or take cognizance, application has to be moved. Then court magistrate issue notice, 14 days notice the accused. You will ask the court will issue a notice. See, there is already a Zimma order from that has moved by the IO. You please give response. Or such person, either the accused or whoever is holding that property. Whoever holding that property, court says the reply of the notice of the accused and see the material facts on the records and see that yes, it is absolutely sure that the properties does not belong to the accused. It belongs to the claimants or whoever it may be. Then if not replied, then even ex parte order, not replied within 14 days. And also very important, serving the notice, getting the reply. If it doesn't serve the purpose of attachment of property, magistrate or judge can, of course, it is only the magistrate can even dispense with serving the notice. If he feels that no, it is a time consuming, I will again go for the disposal of the property. Proceeds of crime be ratably distributed. If there are 3 claimants, particular property, then ratably distributed, magistrate will make an order, give it to the DM, that is the district magistrate. Within 60 days, you ratably distribute according to their claimant or according to their legal ownership. Now the question comes, DM in 60 days, is it sub judice? It is still under trial or whatever it may be. Obviously, accused is accused only. Or pros and cons. Whatever the merits means, if you allow that to entire till the investigation over or the trial is over, now because of the illegal means and all those things, electronic and all those things, some of the movable, immovable properties, they can make an order and they can dispose of the things. Or it, of course, perishable goods, natural decay, and that is already there, isn't it? There it has to be immediate disposal should be there. Pros and cons. And what happens if the accused is acquitted later on? Now have disposed of all the property by some house. So these are the questions that has been added under section 107 that is newly added. Now in the chapter for maintenance of wives and children, section 125. Say earlier child, wife and were there. Later on, central government also made that taking care of the elderly parents, elderly dependent parents. Elderly dependent parents is the obligation of whom? Son. Earlier, if the parents were not taken care by the son, means the parents have to go to the place where the son is residing for the maintenance. But now they changed. It is the parents, wherever they are residing, they can file a petition. Now that has been made, only that change. Then under 162, in treating procedure in case of public nuisance, whatever the earlier things, district magistrate was there, SDO was there, executive magistrate. Now the DCP is also added to deal with the public nuisance cases. So 143 CRPC, magistrate may prohibit repetition or continue of public nuisance. DM, SDM, any person not to repeat. Now added deputy commissioner of police is added. So in newly added 172, all persons has to bound lawful directions of the police. Obviously it is there. So in section 172, the power of police to detain or remove any person resisting, refusing, disregarding to the bona fide directions of the police. Then he can be arrested, but only treat it as a petty offense, 24 hours and releasing. For example, any person is not obeying the lawful directions of the police. Now the police can detain him for 24 hours. More than 24 hours, it becomes illegal custody, and release him. This one. Section 173, provision of zero FIR and DFIR. See, if you see section 173 carefully, the first sentence says that irrespective of area. What does it mean? Zero FIR. 173(1)(2) says about electronic communication. That means says you can file a petition, a complaint electronically also, electronic. Now zero FIR, everybody knows. Earlier was also zero FIR was there, but it was not legally followed, isn't it? Police most of the times what karte, ye police station wo udhar ka hai, Bhubaneswar ka, you go there. There only you file it. Why I should have take? Many of the times they just say that most of the times they do not obey the accept the this one. See, in law, the complaint can be disposed of 3 ways. One is that is the final report. Actually, 173 is this final report, but we police call it as charge sheet. Charge sheet. But it is not charge sheet actually. Charge sheet is one of the form of final report, isn't it? Case can be either closed or charge sheeted, or other way, case can be transferred also. But transferred cases only in exceptional cases due to jurisdiction and all those things. These were there. But in zero FIR, now the transfer of the cases has become prevalent. I, sitting in Cuttack, received a complaint regarding Sambalpur or whatever there is. Received a complaint, written signed complaint. Now I had to make an entry in my GD book in the police station and send it to the concerned jurisdictional court. That is called as zero FIR. I am taking a flight from Bhubaneswar. Somebody has stolen my mobile or some laptop has been theft. I am traveling to Delhi. Now in Delhi, I have 2 options. Go to any of the police station and put up a signed complaint that in this one, that will become out, obviously zero FIR. From Delhi, I travel to Calcutta. Now what I will do? I can e-file also. I can file e-file also. Then what is the thing? I will go to the website, Delhi police or wherever, then I lost my mobile or something else, and this one, the concerned police station will take out that one and send it to the Cuttack or the Bhubaneswar police station jurisdiction. Now the law says after 3 days, within 72 hours, that online complaint has to be signed. But again, that online complaint which has put online need not to be signed and given to the police, that police station only. You traveled from Cuttack, gone to Delhi. Delhi, you filed online complaint, but again you gone to Calcutta. There you take a printout, make a signature and give it to the police station. There it becomes zero FIR. In Delhi, it becomes a EFIR. Both in Delhi and in this one, they have to maintain the GD entry, and both have the obligation to send it to the concerned police station jurisdiction. This is as per this one. And now what happens? If I don't receive the signed complaint within 72 hours or the 3 days, lot of questions were asked in by the judicial officers. See, if we go through the proper this one, dial 100 is there, or a cognizable offense has been made out before me. Do I wait for the FIR to be registered? No, I start. See, the investigation starts when the FIR is registered is on paper only, but not necessarily. Rape has happened. I go and secure the victim first. So it is not necessary on practical terms to register an FIR to start the investigation. On the same thing, you received a complaint from the whatever the police station jurisdiction, signed or unsigned or some. Let us consider it as unsigned. The question is asked on unsigned. Sir, I received unsigned this one. What to do? Now, two things. If the cognizable offense has been made out prima facie, signed, unsigned, you start the investigation by registering a FIR as per Lalita Kumari judgment. But you have a doubt whether cognizable offense made out or not made out, then you can put under section 173(2), that is the preliminary inquiry. In the Lalita Kumari judgment, they told it is 7 days. Now it is said 14 days. 14 days, that is made statutory. But Lalita Kumari judgment is very important because the understanding that one. See, you cannot put the case complaint just for a preliminary inquiry to ascertain whether the case has been made out or not, whether the actual offense has been made. That is the result of investigation. But on prima facie, you came to know that the cognizable offense has been made. Whether it is true or false, register the case. That's why in Lalita Kumari judgment, they have given 4 instances also. Matrimonial disputes, corruption cases, where that is not exhaustive as an example where you can register the P. Now, another thing that has come to the confusion is that 173(1)(2) and 173(2). There it says that in 173(1)(2), you have to substance thereof has to maintain in the suitable book of the police station. It has written. There it means that it has to be mentioned as GD, general diary. And copy as mentioned in section 1 has to be given a free of cost, means it is FIR, isn't it? But in Kerala, while I was taking classes, then they questioned, sir, in 173(1)(2), it says that GD, then shall I give the GD or extra? No. Obviously, GD cannot be given. Only in the rarest of the rare cases, court will ask for the GD. Otherwise, nobody will ask for the GD. So, but from the definition, you can say that 173(1)(2), where the substance thereof has to be written, means it is the GD entries. And the copy has to be given to the victim, means that is the FIR copy. Because as per CRPC, only 3 reports are being by the police. What are those reports? Obviously, 173, then the GD book, and in the case diary. These are the 3. So, we don't call FIR book. FIR book is not considered. FIR book we never call it. FIR we just is the record only. We never call it as FIR book. From this understanding, we can say that it is one, there is the topmost, it is the GD, and thereafter it is the FIR book. Okay. GD, further the provision for lodging information through electronic communication has been added. Already have discussed about that one. 173 BNSS, information in cognizable cases. Okay, EFIR, 0 FIR, that I just mentioned this one. Every information relating to the commission of cognizable offense, irrespective of the area. What does it mean? 0 FIR. Offense. Then 173(2) by electronic communication. What does it mean? EFIR. And to be signed within 3 days by the person giving it to it. Need not submit this signed complaint in the concerned PS only. Submit anywhere. If not signed or more than 3 days, we answered this question. That means you can start the investigation. No need to this one. Another thing. Sometimes, no. Registration of the FIR is very imminent. Very much required. But I did not get a signed copy. What to do? Now what to do? You consider that as an information. Whatever the unsigned record or the information you got, you consider it as an information. Register a suo motu case. And when the complainant comes, you take him as under 161, now 180 of the BNSS as a statement of the witness. So that is there. Sir, shall we close? It is 5:10. What time till? 5. So shall we close for the day? Okay. Thank you so much. And there is a lot of things to be done tomorrow also. 2 more sessions awaiting tomorrow. Thank you for a patient listening. Thank you.
Thank you, sir, for your deliberation. And with this, we have come to end of this first day of our 2 days capacity building training program. And before wrapping the program for today, I extend my heartfelt thanks to Sri Anil Kishore Yadav, Director CPT Bhopal, who traveled from Bhopal and for the purpose of this training program and imparted training, and he shared his valuable deliberations before us, and definitely we are going to be enriched by this. And therefore, from my heart, I extend my gratitude to him. I also thankful to Sri Rajsekhara, Rajsekhara N, Director CDTI Hyderabad, for his deliberation today. And we have, sir, for tomorrow's session also. So thanking you all the participants who have joined physically here, and all the officers of our state who have joined virtually. And I also extend thanks to all other persons who have contributed a lot to make this program a successful one for today. Thank you again, and hopefully I'm hopeful that again we'll meet tomorrow for the other sessions. Thank you.